Yes. there is a case RSA 470/23 एलिफेंट मार देइथिला पुओ को मोर तेन करी कंपनसेशन 2012 रु एजांग मु पाइ पाउने मु देइछि मेमो देइछि
ये कर दो हाँ 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 5 कमीशन 5 अगस्त आसियो
Supplementary list item number 1, election petition.
May I please, madam? The petition has lost the election from 81 Norla Assembly constituency, my lord.
yes
His ground is, my lord, the sole respondent has filed false affidavit in form 26. She has not disclosed her educational qualification correctly, my lord. She has not completed a matriculation, but she has suppressed the same.
she has not completed the matriculation.
I have got under RTA Act, but she has got a certificate from Bihar board. Where it is written that her higher qualification is completed, she has secondary education. But in fact, she has not completed. In that ground, I have challenged.
Where is that information from the under the RTA Act you have received?
Mail.
Date का करो, चाहे सब का date करो. You said false information regarding educational qualification and age.
My lord, in the year 22, she has participated in the Panchayat election. In that election, she has disclosed that her qualification. My lord, I am giving. Yes. In that, she has given her qualification as HSC Government Girls High School, Hon'Ble. She has not disclosed that her higher education, she has completed Board of Secondary Education. Now, that is in the 2022, my lord. But she has submitted in the form 26 that she has completed in the year 2021. That I am placing, my lord, in form 26. In form 26 at column serial number 11, my lord. She has stated.
Yes.
Yes. Highest educational qualification, secondary examination from Bihar Board of Open Schooling and Examination, Patna in the year 2021. When in the year 24, she has disclosed that she has completed her education, higher education in the year 21. But in the 22, in the Gram Panchayat election, she has not disclosed.
All right. Third, admit, issue summons fixing. Yes, sir.
27 second right of September. 5th September.
5th September for filing written statement and settlement of issues.
Okay.
Yes.
Item number 2.
This is an election petition against 41 Shoro SC constituency on the ground of that affidavit the respondent has filed is a false and constant affidavit in as much as 2 columns he has suppressed. One with regard to the pendency of the criminal cases against him. He has disclosed only 4, so there are 6 cases. We have got the information on that from the police, and moreover, in column number 8, he has given not pending any government dues against him, but in fact, there is a government dues to the tune of about 90 lakhs. And for that, a certificate proceeding has also been instituted. He has filed a writ petition. They are also challenging that order. That is also dismissed. That aspect he has not given.
All right. Admit. Issue summons fixing. See date karo. 12th September.
By
for filing written statement and settlement of issues. Yes.
Choto mistake wrongly what miscase prayer.
You filed a miscase?
No, miscase record call for page formal filing.
Yes.
The prayer 41 Soro SC Assembly constituency Rautla Bulle Judy.
Yes. Yes.
Permission.
Learned counsel for the petitioner is permitted to delete the word Rautla occurring in the prayer of IA number 6 of 2024 in court.
Miles. In the notices also.
Yes. Consequential.
My wife's application.
Seems to be a change of line, Mr. Das.
ଏଇ ଲୋକଟା କରିଥିଲି ମୁଁ ଆଗରୁ ଗୋଟେ କେସରେ ବିଧାନ ଏନଗେଜ କରୁଥିଲି ଏଥର କହିଲେ ଆପଣ କରିଦଉନ ମୁଁ ଆଉ କରିବିନି ମୁଁ କଣ ଜାଣିଛି ଗୋଟେ
No, nobody is stopping you. Nobody, I am not stopping.
ଅପୋଜିଟ ପଡିବେ ଏଫେର କରିବି ତା ପାଇଁ ତୁ କର ଏଟା
I am not stopping you. I am not stopping you. Just a obiter dicta.
That's correct.
The obiter dicta to be ignored. Yes, Smapatra.
My lord. Wife's application for transfer from Bhubaneswar to Barampur, my lord. Barampur, Running Judge Family Court.
All right, issue notice to the opposite party by speed post. Fixing a short returnable date, requisites be filed by tomorrow peremptorily. Release this matter on
2nd August,
2nd August,
22nd.
22nd August. Yes. आइए adjournment.
ନା adjournment
ନାଇଁ ନାଇଁ adjournment.
ମୁଁ ଟିକେ
adjournment ତାପରେ ଦେଖିବା
ଗୋଟେ ୱାର୍ଡ କହିଥିଲି
କହୁନାହାନ୍ତି ଗୋଟେ ୱାର୍ଡ ମୁଁ ପୁରା 5ଟା ଯାଏଁ ଶୁଣିବି ଆପଣ ଯଦି କହିବେ
ନାଇଁ ମୁଁ ଏଇଟା ଏମିତି ଜାଣିନି ଯେ 5ଟା ଯାଏଁ
ନା ମୁଁ ଶୁଣିପାରିବି କିନ୍ତୁ ମୋର ଆପଣ
ନାହିଁ କେମିତି କହିବି 5ଟା ଯାଏଁ
ସେ କଥା ଅଲଗା କଥା ମୁଁ ତ ସେ କଥା କହୁନି ଆପଣଙ୍କ ନାହିଁ ବୋଲି
ଆଜ୍ଞା ମତେ ଗୋଟେ ଏନଗେଜ କରିବାକୁ ପଡିବ ଗୋଟେ କାଉନସିଲ
କୋଉଠି ସେଠି
ଭୁବନେଶ୍ୱରରେ
ହୁଁ।
ସେଇଥିପାଇଁ କାହିଁକି
କରିବାକୁ ପଡିବ କଣ କରାଯିବ
ଆଜ୍ଞା
କରିବାକୁ ପଡିବ adjournment petition ଟା ଦେଲେ ସେ ଖାଲି adjourn କରିଦେବେ ଆଉ once these matters are stayed I am finding from since 2017 transfer applications are pending stayed nothing no action is being taken
ନାଇଁ ସେଇଟା ବିକଜ ଅଫ ଦି ଆଜ୍ଞା
All right,
ପ୍ରତିଭା କିଛି କହିବେନି
all right आइए कर दूं further proceeding in CP number 215 of 2024 pending before the learned judge family court Bhubaneswar को family court
ଭୁବନେଶ୍ୱର
भुवनेश्वर दीटा आज्ञा अछि कोटा 1 की 2 अपन न कहल केन जाओ
ନୋଟିସ ଟା
1 की 2 देखंतु
ନୋଟିସ ଟା
family court 2 pending before the honorable learned judge family court 2 Bhubaneswar shall remain stayed till the next date
ନାଇଁ
Item number 4,
My lord, I
For my pleasure, lords. The application of the wife for transfer of the application on the ground that in Kotak.
somebody has appeared through caveat somebody has filed a caveat
yes, my lord.
you
Has
say
not been served.
yes there is a caveat petition anybody appearing for the caveator
My lord, I am on behalf of the opposite party from
Yes.
Learned Counsel Sriram Swarup. We had filed a caveat on the last date and presently, my lord, the case has been, they have filed one CRPC case in family court 2 and 5 execution cases. And that they have exhaustively cross-examined our party. And my lord, that is why sir is absent. So I'm seeking a date for in next week. Sir will be present before this honorable court for hearing.
all right we'll take it up next week then we'll take it up next week the opposite party has already entered appearance through caveat let a copy of the transfer application be served upon her let's this matter next week we'll dispose of
item number 5,
May I please your lordship? My wife instituted a maintenance proceeding in 2022 at Baripada.
yes
Husband has appeared participating there. In 2024, he instituted a proceeding at Baleshwar only to harass the petitioner, and that is how I am before your lordship for transfer of the case. Even section 19 also was amended saying that where wife is instituted a proceeding, he has to institute wherever he resides. irrespective of the
all
condition.
right notice yes
I have prayed for stay of the proceeding.
stay for me
Obliged, man.
item number 6,
Item 6, may I please? I am appearing on behalf of Mr. Rai Mercy. I am appearing on behalf of Mr. Rai Mercy. There are 2 page defects there, Mercy. So I am submitting that
what has happened what is there
2 page defects is there, Mercy. The removal of defects, Mercy.
you're filing a consolidated was there any order was it amended
But that amended, Mercy. IA is for amendment is allowed, Mercy. I intimated also the
First hour morning, they requested me to urgent to some other day. Mr. Upon the associate.
alternates some other day, Mercy.
so you have to file a consolidated cost title
Yes, Mercy.
consolidated writ application in fact have you filed
consolidated page টা মিশুনি
page টা missing, that page
Consolidated ରେ
ଏଇଟା
ପ୍ରଥମ
ମୁଁ
ପେଜ
ଜାଣିଛି।
ଥିଲା ମାନେ ଫାର୍ଷ୍ଟ ଏଡିସନ ଥିଲା 1 ଠୁ 14 ଏବେ ଯୋଉ କନସୋଲିଡେଟ ଦେଇଛନ୍ତି 1 ଠୁ 18 ଆଚ୍ଛା ଯୋଉ ତାପରେ 15 ଠୁ 33 ପର୍ଯ୍ୟନ୍ତ ଯୋଉ ଥିଲା ପେଜଟା ସେଟା ସବୁ ପେଜିଂ ଭୁଲ ହବ ସବୁ ପେଜିଂ ଗୁଡାକ ଆଉଥରେ ରିପେଜିନେସନ
Author coordinate, author coordinate, author coordinate. The pagination, correct pagination of the consolidated rate application be made and filed again. List this matter next week.
ଏବଂ ସେଗୁଡା ସେଇ ହିସାବରେ ରନିଂ ପେଜ ବି ସବୁ ଯାକ କଭର ହବ ଆଗ ଦେଇ ସାରିଲା ପରେ
ସେ ଆଗ ଦେଲା ପରେ
ଆଜ୍ଞା ଆଜ୍ଞା
ସେ ଆଗ ଫାଇଲ
ଭିତରେ ଦିଅ
office to thereafter the office is to paginate the entire brief.
ରନିଂ ପେଜେସ
Paginate the entire brief hele hala.
ମାନ ମାନ
Yes.
Item number 7.
ଏନି ଡେଟ୍ ଫିକ୍ସ ମ୍ୟାନ
Next week, next Thursday,
ନେକ୍ସଟ ୱିକ୍ ମ୍ୟାନ
next Thursday.
Next. Can I please, your lords? You are on the last.
Mr. Joshi, I think you will have to leave that chair. Please come to the other chair. That is the arguing counsel chair. I think it is mentioned also, isn't it?
Yes. ଲେଖା ହେଇଛି ପଛରେ ଲେଖା ହେଇଛି ପଢିନାହାନ୍ତି।
Yes.
In item 7, your lordship.
You remember Justice PC Naik?
Old court number 2.
Old court number 2. Yes.
In item 7, your lordship directed me to get instructions from state government about taking over of that primary school.
Oh, yes, yes, yes.
No decision has yet been taken. If your lordship directs that a decision be taken either on this side or that side, that I think would be.
I think some decision was taken against you.
Yes.
Yeah, that was the impugned.
That is the impugned order.
Yes.
But further,
Yes, that is the impugned order, my lord.
to obtain the current status of the direction to take over the school in question.
Section 9,
Section 9.
decision of 26/4/2014.
This is impugned.
Lords.
So what further?
If your lordship disposes of saying that it is for the state government to take a decision considering the present state of affairs in the school.
What do you say?
Your lords.
This decision was taken way back in the year 2014. 10 years have passed. So situation may have changed. Let them
Yeah.
take.
If they don't
Or-
want to take, they may make some arrangement about the
Yes,
students and the teachers.
So I will permit you to submit a fresh representation containing all the development facts as also your present, supposing, suggesting an alternative also. But I'll not say pass that in order, but it should be, prudent on your part to suggest some alternatives.
Yeah.
That if the school is unable to be taken over, then we should be protected by such and such.
Yes, that would be better, yes.
That would be better. The petitioner has filed this writ application with the following prayer. Learned State Council, in course of hearing, as directed, Learned State Council has obtained instructions as regards the current status of the matter regarding taking over of the school in question. It is stated that no decision has been taken in the matter as yet. This court finds that the order rejecting the request to take over the school was passed on 26/4/2014. That is 10 years before. It is stated at the bar that there have been several developments in the meantime. Taking into consideration all the above facts and with the facts, this court finds no reason to keep the writ petition pending. Stop. It would rather be prudent to permit the petitioner to approach the concerned authority, ventilating their grievances exhaustively, extensively looking. In such in such event, the authority, the concerned authority shall be in a better position to take stock of the current situation so as to take a informed decision in the case, informed decision in the matter. Stop. The writ application is therefore disposed of, granting liberty to the petitioners to submit a detailed representation addressed to the Secretary of the Department of School and Mass Education, Government of Odisha. Stop. If such representation is submitted within 2 weeks from today,
3 weeks, let's say, because
within 3 weeks from today, the Secretary shall do well to consider the same and pass a reasoned order after granting opportunity of hearing to the petitioners. Stop. In doing so, in disposing of the writ application, this court hopes and trusts that the Secretary shall take due note of the fact that the petitioners are similarly situated as the employees of the Orient Colliery Hindi Primary School, which was taken over by the government pursuant to the direction of the Supreme Court of India. That's all. Yes. A decision in this regard shall be taken within 2 months from the date of filing of the representation. Yes.
and that will be communicated.
Let's say that without the influence of the Annex 9 rejection, earlier rejection.
Annex 9 has to, lordship has to.
It goes without saying that while disposing of the writ application, disposing of the representation, the Secretary shall not be influenced by the earlier order of rejection dated
26/4/2014.
26/4/2014.
Subject to correction, only one submission. That's OP4 has filed a counter affidavit stating therein that they have recommended my case to the, that has been reflected in paragraph 3 of the.
I will not go to the detail. I'll make a general observation.
Let's.
I'm taking due note of the fact that person similarly situated will and further, Supreme Court and further that the Mahanadi Coalfields has recommended taking over of the school. Sitting.
Grateful.
Item number 8.
Urgent copy.
Urgent copy.
In this case, your lordship had directed for producing the records of selection. That having not reached your lordship on the last occasion, that is on 10/7, directed for hearing of the case.
In spite of that, again on 18/7, I directed you to produce the records.
Yes, till then it has not been issued.
Why are they not producing the record? What is happening? Why are you forcing the court to pass an adverse order? I don't understand, sir.
They should not have done this.
You have just to produce the record.
Your lordship has already heard and about to give the reserve the judgment.
Yes, what is the matter?
Issue is I am satisfying your lordship. LCR is not required. Lordship, here I have challenged the order of the appellate authority. I am the resident within the service area, not disputed. It is on record. What I have done, I applied for a certificate, resident certificate. Resident certificate, the Tahsildar, instead of my husband's name, he written down my father's name. That is why they rejected my application and directed me to produce a fresh certificate in the name of the husband. I produced it, but on the date of I received the certificate from the Tahsildar, I produced it, but it is beyond the cut-off date. of the advertisement. My submission is, as per the guideline, as per the mandates of the advertisement, the requirement is the resident. He must be resident. In both the certificates I produced before the authority, the residence is same. Resident is not disputed. Even the authority, lady supervisor, Anganwadi worker, CDPO, 3 persons inquired me that I am the service area. So I could not have been required to produce the second certificate. My first certificate is valid. Even in the miscellaneous certificates rules, there is provision of father's name or the husband's name. Both are there. So merely my father's name was included in the resident certificate, first resident certificate, which was filed within the time and along with the application. That cannot be, for that reason, I cannot be disqualified, because the advertisement as well as the guideline of the Anganwadi worker, they say that I must be the
So
resident.
why was the record called for?
Record call for lordship for this reason, while I was before the last session, the previous year session, I was argued. They have produced lordship kindly see page 30.
To produce the original file relating to selection of Anganwadi worker, Vishwanathpur Mini Anganwadi Center.
Page
I have
30,
been passing this order since February.
page 30 lordship, they have submitted a regime that the resident certificate not submitted in the time of verification.
That is why I wanted.
That is why lordship.
So let him come tomorrow with the file. Let him come tomorrow. Who is to produce the file? The ADM. I'll show you. You see, I passed this order on 2/2/2023.
Yes.
Matter was again adjourned on 23rd February. Again on 26th, London State Council request for some time.
Yes. In
To
fact,
comply
they
with
are at fault.
26/6, then 10/7/2024, 18/7/2024. Today we are in 25th.
May I
July.
say it be on Monday, because
No, let him come tomorrow. Let him come tomorrow. Tomorrow at 10:30 he should be here with the file. That's it. Who is to bring that file? CDPO.
CDPO.
Yes. Why? How can he? How can? Huh? And also he'll file, he or she, whoever is, he'll file an affidavit why contempt shall not be drawn against for non-compliance of the order. But this High Court, it has been made a joke. No.
They have been intimated, but
No. Can you please pass on the letter by which they were intimated? Man, High Court jaha jibo semane bartan ignore କରୁଛନ୍ତି.
13/7 the last letter was issued.
No, first letter.
First was
2/2/2024 the order was passed.
yes. In June. There have been 3 letters.
Yes. The 28 is
That was the first.
no. 7/2 is the first. 7/2 and 26/6. That is the letter. And what is the last letter?
Last was
And 18/7. By order dated 2/2/2023. 2/2/2023. This court directed production of the original file relating to selection of Anganwadi worker of Vishwanathpur Mini Anganwadi Center, for which the State Council was directed to do the needful. From the records produced by the State Council, it appears that a letter was issued by the AGA, Additional Government Advocate, to the ADM as well as CDPO on 7/2/2023 to produce the records, produce the file. Again, on 26/29/6/2024, the AGA requested the aforementioned officials to produce the file. Yet again, by letter dated 18/20, date .7/2024, the ADM was requested to produce the file, specifically stating that this court had expressed its displeasure for non-production of the original records. In spite of such communication, the record has not been produced. This prima facie shows that the concerned authorities have scant regard to the orders passed by this court, which is nothing but a direct affront to the hallowed principle of rule of law. Let the ADM, किए था ना, को उजागर?
ADM
Baleswar appear before this court tomorrow at 10:30 AM with the concerned file, and also file an affidavit as to why, explaining why the order of this court was not complied with earlier, even though repeated requests were made by the State Council. List this matter tomorrow at the top of the list. Top of the list, normal.
My lord, politically.
Yes.
Advertisement for Vishwanathapur Mini Anganwadi Center.
Yeah, so how is it? Let it come tomorrow. Let the file.
They are saying that our father's house and husband house.
I am not hearing on merits.
Okay. RTI document file
Are
separate village, tar bhi separate.
No, copy. No. This court would like
village.
list this matter tomorrow.
Okay.
Yes.
Item number 9.
If it doesn't appear, I'll issue an NBW.
I will want
No, I will direct the SP to arrest him and produce him before me.
that is the procedure followed by this only.
I can go to the last extent,
Yes, this has been the procedure.
I'll take it to the logical conclusion.
Has
So
to.
let him produce a file and let him file an affidavit, and the explanation must be proper. Otherwise, I'll draw up a contempt proceeding against him. There are also
Yeah.
Yes, Mr. Mishra.
Okay, the law.
This is a part matter. Oh, yesterday's matter.
They just state a matter.
Yes.
They said,
Yes.
passed over, I said, requested your lordship.
Anybody is there for the other side?
I'm there.
He's for the person who was appointed.
In the termination vacancy.
Termination.
What about the management? Mr. Sharma was
He's
appearing.
not coming.
Not coming. What can we do?
Let me place of the.
2010 matter, I cannot wait.
Yes, ma'am. Let me place.
And Mr. Rafa is there for the other side. He has nothing to say, but nevertheless,
He's there, he's in.
I will have some space.
I guess the termination vacancy very
I
limited.
have a right to be heard.
You have a right to be heard, but very limited.
That judgments are there, starting from
What
there.
judgment, sir? What judgment?
But I have a right to be heard, to agitate my point.
Agitate your point.
Not on behalf of the governing body.
Not necessarily not. Governing body katha mu kahin kahin. Whatever is the fact and whatever is the law, I can assist my lords on that. That's all.
Lordship, can you see on
Yes.
page 11? Annexure
Page?
1. Page 11, annexure 1.
Yes.
The petitioner was appointed as a.
You are Sarada Devi.
Sarada Devi.
Yes.
I was appointed on 31st/7/90 in the first post of lecturer in Odia. That's got it, madam.
Lecturer.
Sarada Devi, Doctor of such and such, or Bile such and such, is hereby appointed lecturer in Odia. Bottom part, let's say, look at the date is 31st/7/90. Then, my lord, due to my illness, I was on leave. My lord, those documents, medical documents are then, my lord, page 15. Page 15. The defunct managing committee wrote me a letter, wrote the letter, Director, you are not accepting or receiving our letters. Then you'll also get it on page 16. Second paragraph. In letter number 285, dated 23rd/7/2003, the authority has terminated your service. Hence, no explanation in this regard can be entertained by the undersigned. So let's look at the date. That is 23/7/2003. Then you lordship kindly see my page 19. Then they compelled me to file a resignation. I filed a resignation. However, Let's say look at page 19, annexure 4. Let's say look at the bottom, that is dated 25th November 2003. I withdraw the resignation. That's the last paragraph. In view of, I am fully convinced that my resignation letter has not been accepted with the background that I have not received any written confirmation till date. Hence, I request you, your kind honor, to withdraw the said resignation letter and allow me to join the college at the earliest. May I request you kindly consider my plea and the resignation letter may be treated as cancelled at the earliest. Then your lordship kindly turn to next page.
Annexure 5.
Annexure 5 color. I'm sorry, page 21. Annexure 6. Again, the authority is writing last paragraph. Considering the fact above, the authority painfully terminate your service from today, that is 6/8/2003. They say on 23/7/2003 they have terminated the service. Again, in this letter, they are saying, considering the facts above, the authority painfully terminate service with effect from 6/8/2003. Then my lord, come to the page 22. So I approach the director. Director, second paragraph. I was upset with that. I read the second paragraph. The ex-secretary governing body of the college, Sri Behera, in course of hearing, produced the original GB resolution book, wherein it is found that governing body in its meeting on 6/12, my lord, I withdraw on 25/11/2003. They say they accepted my resignation on 6/12/2000, twice terminated. 23/7, 6/8. Then I filed a resignation that was withdrawn by me on 25/11. Director considered and they submitted, the authority submitted, they accepted my resignation on 6/12, which cannot be, my humble submission. Because so far the law is concerned, if I file a resignation and it is accepted before withdrawal, then I cannot argue it is binding on me and it has to be said. But when I withdraw the resignation prior to the date of approval, then I have every right to say that I have not resigned. Then, my lord, I approach the tribunal. Then tribunal said, let's look at page 23. Third paragraph. No appeal is maintainable before this forum against the order of the director. Therefore, accordingly, it is not maintainable. Then I approach through a writ application. Then, my lord, we can turn to the date chart.
You have given a date chart?
Yes, sir. Date chart is available at page 2.
Page?
Page 2 onwards, sir.
In the writ petition.
In the writ petition.
Okay.
Then you can see I filed a WPC number 96 that is dated August 2005. 9658/2000 was filed before this honorable court. Then my lord, the order passed to convert the writ petition as appeal. Then I filed the FAO. FAO was disposed of, granting liberty to the appellant to file a writ application. And this is the present writ application before the lordship. Now my entire contention before the lordship, and then again the said case was also disposed of, only taking into account the decision of the director as at page 22. That may not be available. That is available in writ appeal. That writ appeal has come or not. Which is the matter was remitted back for hearing.
Writ appeal
This writ application was disposed of.
mention writ appeal.
Writ appeal is there.
Order number 3.
Order number 67/2019. That may be available in the Hard Learning Council for the parties such and such. It is stated that by virtue of the order passed at Annexure 7, dated 17/9/2000, the petitioner who was terminated from service filed a repentance before the director. It was also specified that the action taken by the governing is well justified. Therefore, the appeal so filed by the petitioner has been rejected.
So it has been restored. It has been restored and now it is to be.
Now it has been. So this is the case about The question for consideration is, insofar as termination is concerned, no opportunity of hearing was given to me because as they admitted that I have not received any letter. Or deliberately, they use the word deliberately. Even considering for the sake of argument that I have not received and I have not deliberately received. They should initiate a departure proceeding. They should issue a memo of charges. They can appoint the marshalling officer. In my absence, they have to consider everything and pass a final order, which they have not done. So question of termination is bad, as well as purely manipulation, only to accommodate someone, because it was in the year 2004. On 20th February 2004, the college was eligible to receive grant in it. Admittedly, from 90 to 2003, I was working. Therefore, my humble submission is the order of the director is liable to be passed, and I should be, and I mean, I'm also retired also. I'm now 63. If you also will allow this, I will get some retirement benefits and other things. That's all.
Yes.
But I'll just speak what is not said before, my lords.
But you cannot say anything on behalf of the management.
Certainly not. How can I?
Only, how do you come?
I will bring the facts to my lord's notice, which is not submitted, the facts which is available on record, and I will justify the director's order because consequent upon either her resignation or termination, I was appointed. I have continued for long 24 years in the college. Now I am continuing in the college. I have received grantinate. I am enjoying grantinate from the government. Today, if any order is passed in favor of the petitioner to reinstate or any of that nature, I will be affected. And I have been continuing in the college since 24 years. See, without affecting me, any order is passed, certainly I will have no cause of action.
Obviously.
I cannot be reinstated.
I think.
I'm 64.
So, my lord, without affecting me, if they are getting any benefit, if your lordship will clarify that, Lord, I will have certainly no grievance. I'll remain as it is. But today, what is the position, my lord? Lordship will see, admittedly, she has attained the age of retirement. And admitted position of law, if your lordship says that Cooperative Society's case, Supreme Court judgment says, a person not in employment is not entitled to regularization. A person not in employment is not entitled to any order of regularization.
It's not a question of regularization.
So, regularization in the sense approval. Now, what are you asking? Approval of service. And you have admittedly attained the age of superannuation.
No. She has impugned the order of the director.
Yes, now I'll take your lordship to the director's order. Whether she can impugn the director's order at all. Kindly see the director's order. That is what is not placed. Kindly see what is the director's order. You have expressed your satisfaction before the director. Having agreed before the director that you will be happy with that experience certificate. Now, how do you turn around and challenge the order?
Where is the director's order?
Yes, kindly see the director's order. Yes, Lord, Annexure 7. Kindly see the director's order. But now, how can you challenge this order which was passed on your consent? The petition dated 3304. Plus, you got it, man?
Yes.
Yes. Now, kindly see this date 3/3/2024. And what is the alleged date of your termination is 2003. As per the executive instruction, you are supposed to challenge that within a period of 30 days. If I can show that executive instruction, not because it was an already college. You are supposed to challenge termination, if any, within a period of 30 days. Now, 3/3/2004, Srimati Sarada Devi, ex-lecturer in Odia GB, so article regarding her illegal termination from service of the GB, service by the GB of the college was duly examined by the Director of Higher Education, Odisha. The petition, so-and-so lecturer in Odia, ex-secretary of the GP, only were present at the time of hearing on 21/8/2004 for the aforesaid matter. The ex-secretary of the GB of the college, Sri Beura, in course of hearing, produced the original GB resolution book, wherein it is found that GB in its meeting dated 6/12/2003 has accepted the resignation of so-and-so on the request made by Srimati Devi in her petition dated 28/10/2003 and accordingly issued necessary order in this regard, right order dated 16/5/2004.
she has also been issued with an experience certificate on the said date, which could not be received by the petitioner on the given address. Given address has not been served in my present. The petitioner is satisfied with the action of the GB taken on the representation of the applicant, and this dispose of the representation certificate. Last para, my lords, may kindness. Now, what is the problem? If this person's husband is a defense officer, then she remained absent from the college and went back to her husband. She wanted to lead her life with her husband. For a considerable period, she did not come to the college, remained unauthorized absent. So even these notices, letters from the college were served to her residence, could not be served on her because she stayed outside the state with her husband in the defense somewhere. So that is the reason the governing body was constant to pass the order of termination. Now the termination order, rightly or wrongly, if a lordship sees that termination order, page 20, man. No, I'm sorry. The termination order is page 21, man. Page 21. Kindly see, man. This was passed 6/8/2003. Kindly see this termination order, man. In continuance of this letter number so and so, it is to inform you that since today you have not received any reply to this letter, you did not reply our previous letter dated 15/4/23 and letter dated so and so so and so. Even after summer vacation, you did not resume your duties. You are absent from 12/4/2003 till date, and you have not applied for leave for the period. Your from previous leave is also not sufficient to remain absent for such long period. You have not taken any quarter leaving permission and did not inform about your permanent address. Even after so many correspondence, you did not take any opportunity of personal hearing. You did not explain your misconduct of long absence. You did not care to the letters of the principal and secretary. Considering your effort, authority painfully terminated the service 6/8/2003. But
This is to be considered by the court. You cannot justify issuance of this letter. This was issued prior to your joining.
obviously,
What are the circumstances you are
justifying?
Mr. Doctor, you are not supposed to know. You have made a valid submission that you have referred to the director's order. That is one part. And second part, which you have said at the beginning, that you have been appointed, your services were approved, you have been admitted to the granted aid for,
Right.
and you have rendered in the
So
meantime.
protecting me, if any order is
No, no,
passed.
I have objection to that.
But let me complete. I have not yet completed.
Oh, sorry, answer. Let me.
Yes.
Let me complete.
Please.
So this letter which you are referring to,
Right.
you cannot justify it. You can refer to it.
I am not justifying. I am just bringing this letter. It's it's my duty to bring to my lord's
So
notice.
the management, yesterday the matter was there.
So
Today I adjourned it.
today, I'm
Deliberately the
what is
management.
all about, my lord? I'm telling the law.
No, I'll tell you one thing. The management is deliberately.
My lords, kindly consider, today, rightly or wrongly, termination order has been passed. After the termination, you are resigning. Now the governing body is saying that there is no point in resigning because we have already terminated your services. But that I am not defending governing body. No. For the moment, your lordship may accept whatever fact that only I am bringing it to my lord's notice. Governing body is saying that since we have terminated you, there is no question of resignation. So at this juncture, what you did is, after you have belatedly approached the director, 30 days period, my lords may kindly see.
The 83 circular.
Sir.
It has been followed by, it has been repealed by another circular of 2000, where that limitation period has been taken away.
Let him approach the director. Before the director, you said that I am satisfied if an experience certificate is given to me. I don't want any further relief. So if having your question is,
So here, this is again open to interpretation. Come to the page 22, the last paragraph which you read out.
yes.
The petitioner is satisfied with the action of the UB. Well, this is open to interpretation. Whether the petitioner says that she is satisfied, or it is your satisfaction that you are recording it.
Petitioner is satisfied on the basis of her
He does not say that the petitioner.
That is the yes, 82 Supreme Court is there. What happened before the tribunal, that cannot be.
Pass on that judgment.
Koota sir, ମୁଁ ଦଉଛି
82 Supreme Court ର କଣ ଯଦି ଆପଣ ଜାଣିଛନ୍ତି ଦିଅନ୍ତୁ ସେଟା ମୋର ଆଉ ଗୋଟେ judgment such assistant is
sir 82 para 4 ଦେଖୁନାହାନ୍ତି ଦେଖନ୍ତୁ
ହଁ ମୁଁ କାଲି ସେଇଆ କହିଲି ଆରେଷ୍ଟ ନାହିଁ ବୋଲି ସେ ମୋତେ ମନା କରୁଛି
ସାର୍ କଣ କହିଲେ
ନା I was searching this judgment for another. So thank you for it. My research assistant has been spending burning midnight oil for this, but could not get it. I told him R.S. Naik. He came out with that A.R. Athule versus R.S. Naik.
No. 82 Supreme.
This is also R.S. Naik. I remember it distinctly. I had used this judgment.
Yes.
So you have to approach the same court and file an affidavit.
Yes.
But there, in that case, what would have happened is he should have written that according to the petitioner, he is satisfied.
So it is only the same authority can say.
Or the petitioner says, why should I interpret it in that way? Why not I interpret it? This is his satisfaction.
No. Unless the petitioner says, how can he record this?
It is his record.
So if at all there is any confusion, he will have to approach the same authority again. It is for not your lordships to consider it.
Anyway.
Kindly consider this, my lord. And one more aspect, my lord. Today, my lord, one more valid submission before my.
Yes.
What is he questioning? Termination. But from the submission, what I have understood is, what is the submission is made? That no proceeding, no charge, no opportunity, termination order has been passed. Straightway, this is the submission. Today, if your lordship set aside let us go to the extreme, that your lordship will set aside the termination. The course open is LIS of India, 2004 Supreme Court. That says, if a court set aside an order of punishment on the ground of lack of natural justice, it has to be relegated back to the stage from where it was wrong. Straightway, there cannot be. Supreme Court says, no order of reinstatement can be passed. It has to go. Now, today, you are already retired. And after 25 years, lordship will remand the matter back for a fresh initiation of the proceeding, give opportunity to the governing body. Lordship will kindly see whether justice will be done.
All right. I'm closing.
My answer is very simple, madam. Let's get down to page 6. Page 6, paragraph 3D. That he said that I conceded, I was not present, not say that. Page 6, madam. Paragraph 3D. But the petitioner wrong legal advice moved in good the director disposed of the same on 7/9/2004 and the same order is received by the petitioner on 2/11/2004 in the said order dated such and such. The director recorded that in presence of the petitioner, hearing of the case was conducted, which is not correct. So the petitioner again on 6/11/2004 filed an application to review of the order, but that evoked no response.
Very good, my lord. Then you should have.
Then the director is connived with the governing body that I conceded. I have got no answer to this.
So,
categorical affidavit of mine that I was not present. No, I know.
But Mr. Mishra,
Conceded.
you will also appreciate one fact that which he made the submission that he made at the beginning, that any order that can be passed in your favor without disturbing his position, because he has been validly appointed. He has been validly appointed. You can't. His appointment is. You are not specifically questioning his appointment.
No, I'm not. I said termination twice terminated.
So, and this is a
withdraw the
no, Mr. Mishra, this is a 2010 matter. 14 years have passed.
But so far the facts are concerned in relation to director letter, these contentions of mine may be taken note of.
Yes, certainly.
That I was not present, nor I was heard.
We will take a
conceding does not arise.
The court will court will try to take a larger picture, larger view of the matter.
Draw balance.
Draw balance.
That's balance. In all such cases, in similar cases, I have also passed orders.
My lords. That will be in fact.
Anyway, thank you, Mr. Ratha, for helping me in the other matter.
So grateful, my lord. So grateful.
Yesterday, I told him that there is a matter, that there is a judgment you find out. I distinctly remember R.S. Naik.
82 Supreme Court.
So what he did, he found out, but he found out the other R.S. Naik.
Not that.
A.R. Athule versus R.S. Naik.
There is one more judgment. I'll also in the line of this judgment, I'll say 60, 64 or 63. That says, in a proceeding before the court, when two lords have made submission, subsequent thereto a lord makes a submission, though I have not made this submission, that can only be done by filing an application for the consent of the other lord.
And in the same court.
Yes.
That is
That's right.
Anyway. Item 10. No. Take back the judgment. We have taken out to note of the citation.
That be there. We have.
Oh. Yes, item 10.
Item 10.
Yeah, all right. Hearing concluded, judgment is up.
Yes. Here, the matter
Yes, Mr.
Yes,
Joshi.
yes, ma'am. The matter leads to that selection and appointment of Anganwadi worker. Here I have challenged the selection of appointment of OP number 4 as Anganwadi worker in respect of that Anganwadi center under the CDPO board and Panchayat Samiti in the district of Nuapada.
Was it heard earlier?
My lord,
Was it heard earlier?
no, not before your lordship, before.
Yes.
Your lordship, kindly come to that Annexure 1, page 8.
Annexure 1 is the list. You are Gitanjali Padhi.
Yes, my name is serial number
Gitanjali Pod.
Gitanjali Pood.
Yes.
My name is serial number 3.
Yes.
I've got out of 750, 362 mark, 48%.
Yes.
Whereas the selected candidate OP number 1, he has got 41 mark, 41%. Out of 750, 305.
Add 10% or?
No, you also see the guideline governing field of that issuance. You also see the count of it filed by the state at page 26.
26.
Yes, well. Revised guideline for selection of Anganwadi worker. You
Yes.
got it, my lord. You see, percentage of marks obtained in the matriculation examination shall be the basis for drawing a merit list among applicants. So for selection and appointment of Anganwadi worker is a person having highest mark in the HSC.
But how comparatively, how do you make a comparative assessment?
I'm just coming. In addition to the above, the preferential additional percentage will be given to the following categories. Scheduled tribe, scheduled caste, 10%, not 10 marks. Out of the total marks he has secured, 10% is to be added. You'll also see at page 8, my lord. She has secured 41%. I have secured 48%.
So 4%, 4 marks are to be added.
1 is equal to 45.4. I have 48%. 10 mark is added. 10%, not 10 marks.
Yes.
So that is why I'm to be selected.
Yes, Mr. Sao.
Percentage, not that was given in the in addition to the above, additional percentage mark will be given. 10%, not 10 marks. And another factor is that this is the scheduled tribe area.
That is what he's saying. 10%. 10% of the marks.
Scheduled tribe, in the scheduled tribe area, your lordship may kindly see running our my counter in the said guidelines, para 7.
Para 7, yes.
In the schedule area, SC/ST candidates shall be selected as Anganwadi worker having educational qualification as provided under para 3. In case no SC/ST candidate is available in the schedule area by the Anganwadi center, then suitable SC/ST candidate can be selected. I am a scheduled tribe person. For that reason, I was selected.
Yes, I would like to know the response of the state. It says percentage.
Only annexure 1 has been placed, my lord. Thereafter,
obviously.
no, thereafter, my lord, another clarification.
Yes.
Annexure C by 3, my lord. Then note 12.
Yes.
That is on 4/8/2007. The appellate authority had also considered the same, my lord. They are the 10%. Now it has been 10 point, my lord.
Well, the additional percentage of marks given for different special categories are as per point 3 of the revised guidelines may be added as additional points. SC/ST will get 10
Irrespective of the
points.
percentage of the mark they have secured. So taking into consideration both the guidelines, the selection procedure has been held and that has been carried out.
Yes, Mr. Joshi.
The 10 points will also see the revised guideline placed by my learned friend at page 31. The revised guideline for selection of Anganwadi worker. In continuance with the earlier guideline referred to above, the following points clarified. The additional percentage of marks given for different special categories as per point 3 of the revised guidelines may be added as additional points. That is, ST/SC candidate will get 10 points irrespective of the percentage of marks.
Points ଦେଇକି କରିଲେ 51.
ଆଜ୍ଞା.
Points ଦେଲାଠୁ 51 ହେଇଗଲା. କଣ କରିବେ?
Here, she has admittedly OP number 4 has secured 41%.
41% ରେ 10 points ମିଶିଗଲେ 51 ହେଇଗଲା.
51 ହେଇଗଲା.
ସରିଗଲା.
Only this point. Next.
ସାରି ଦଉଛି.
ଆଜ୍ଞା.
ସାରି ଦଉଛି. ଜଜମେଣ୍ଟ ଡାକି ଦଉଛି. ବସନ୍ତୁ. I went to court number 2. ନାଇଁ ଯାଉନା. ଯୋଉଠି ସୁବିଧା ସେଠିକି ଯିବେ ନା. The petitioner has approached this court with the following prayer. The facts of the case are that pursuant to an advertisement issued by the CDPO Boden in the district of Nuapada on 5/12/2009 inviting applications for selection of Anganwadi workers in respect of different Anganwadi centers, comma, the petitioner applied for engagement in Keuburla Anganwadi Center. Stop. In the selection process that followed, the petitioner and two other candidates, including the present opposite party number 4, were considered. On a comparative assessment of their relative merit, the petitioner was found to have secured 48 points, while the opposite party number 4 secured 51 points. Stop. The other candidate secured 50 points. As such, appointment order was issued. Appointment order was issued in favor of opposite party number 4.
Yes, sir.
Was issued in favor of opposite party number 4. According to the petitioner, the assessment of relative merit by the selection committee is contrary to the revised guidelines issued by the government in Women and Child Development Department, in as much as clause 3 of the said guidelines provides that additional 10% of marks shall be granted to the scheduled tribe / scheduled caste candidates. According to the petitioner, she having secured 48% in the matriculation examination and the opposite party number 4 41%, only 10% of said marks, that is 4.1 marks, ought to have been added instead of 10. She therefore filed an appeal. Where is the impute order? Yes, she therefore filed an appeal, being Miss Appeal number 48 of 2010 before the ADM Nuapada. The ADM, while ordered 14/1/2011, rejected the appeal as he found no illegality or infirmity in the method of selection adopted by the selection committee. Impugning such order, the petitioner has approached this court with the prayer as quoted above. Counter affidavit has been filed by the state opposite parties, bracket opposite party number 1, 2, and 3.
1, 2, 3 bill.
Justifying the selection of opposite party number 4. It is stated that as per the revised guidelines read with the clarification issued on 4/8/2007, yes, 10 points are to be added to the marks secured in the, to the percentage of marks secured in the matriculation examination. Stop. The opposite party number 4, having secured 41% marks in the matriculation examination, was therefore selected as adding 10 points to said marks, comma, her total tally came to 51%. 51 points, which is more than what the petitioner secured. Stop. Counter affidavit has also been filed by the private opposite party number 4, more or less on the same lines as the state. Stop. Heard Sri S.K. Joshi, learned counsel for the petitioner, Sri S.N. Patnaik, learned AGA for the state, and Sri A.K. Sahu, learned counsel appearing for the opposite party number 4. Sri Sahu assails the impugned order by submitting that the selection committee committed gross error in going beyond the revised guidelines dated 2/5/2007 in as much as per clause 3 thereof, the percentage of marks obtained in the matriculation examination shall be the basis of drawing a merit list among the applicants. So admittedly, the petitioner secured 48%, while opposite party number 4 secured 41% marks in the matriculation examination. According to Sri Joshi, therefore, the selection of opposite party number 4 was entirely contrary to the guidelines. Sri S.N. Patnaik learned AGA submits that the government in the WCD department issued a clarification on 4/8/2007, wherein wherein clause 3 of the revised guidelines dated 2/5/2007 was specifically clarified to the effect that the SC/ST candidates will get 10 points irrespective of the percentage of marks secured in the qualifying examination. As such, no illegality was committed by the selection committee. Sri Sahu, current counsel appearing for the private opposite party, makes similar arguments as the state counsel and submits in addition that opposite party number 4, being a ST candidate, is entitled to 10 points.
I'm clarifying one thing. The advertisement questions, the area is not coming under the MADA area. So for MADA area is concerned, only ST/SC candidates are to be appointed. It is not neither scheduled area nor a MADA.
No. In general,
Yes.
SC/ST candidates are entitled to 10 points more.
Yes, yes.
That is irrespective of the area.
Area, yes, it is.
So that may not be very relevant, Mr. Joshi. He is entitled to addition of 10 points to the marks secured by her in the matriculation examination. Correct. The facts of the case are not disputed. From the copy of the comparative statement of three candidates, it actually 5 candidates. So 5 candidates. Appropriate jagah 5 crore. It is seen that out of 5 candidates, the petitioner was found to have secured 48% marks in the matriculation examination. Further, she being an OBC candidate, no further addition was made. On the contrary, on the other hand, the opposite party number 4 was found to have secured 41% marks in the matriculation examination, and 10 points were added as she belongs to the ST category. The clause 3 of the revised guidelines stated 2/5/2007 read as follows. Quote kar do. This guidelines was subsequently followed by a clarification issued by the government on 4/8/2007, specifically as regards the additional marks, additional points, as envisaged under clause 3 of the guidelines stated 2/5/2007. The guidelines said clarification inter alia provided as follows. Quote kar do. Kali point 1 ta quote kariye. 2 ta kar do. तब मूल का पर प्रश्न कर देगा It is therefore abundantly clear that the word percentage used in clause 3 of the guidelines, revised guidelines dated 2/5/2007 is to be treated as points within inverted comma. As such, the contention advanced by Sri Joshi that only 10% marks, that is 4.1, ought to have been added to the marks secured in the matriculation examination cannot be accepted. Stop. In view of the clarification, there can be no manner of doubt that 10 points are to be added and not percentage. Stop. The opposite party number 4, having secured 41%, adding 10%, makes her the highest scoring candidate at 51 points. Stop. Perusal of the impugned order reveals that the ADM has taken note of these facts to reject the appeal. Stop. In view from what has been narrated here and before, this court fully concurs with the finding of the ADM and therefore finds no reason to interfere in the matter. Stop. In the result, the writ application is found to be devoid of merit and is therefore dismissed. There shall be no order as to cost. Yes.
Item number 11.
Yes.
Item 11 minutes, no instruction on behalf of my learned senior.
No instruction dispose of.
Here, that is.
First, 14863 of 2012.
Here I am,
dispose of.
I am for opposite party number 4. I am the, my lord, I have been appointed as Anganwadi.
In the connected matter.
Yes.
First case dispose of
opposite party number because I have been appointed as Anganwadi worker and continue since 2011.
So this sub-item you have filed for implementation?
No, I am for the petitioner.
For implementation of the order?
No. What happens, your lordship? ADM, she had preferred a appeal challenging my appointment before the ADM Dhenkanal. And ADM has allowed her appeal on the ground that I am not belongs to that residence certificate, residence area. But residence certificate was issued in my favor. After my marriage, I have been shifted to my parental house. And accordingly, residence certificate was issued. And appointment was issued, order was issued, and a selection committee has already rejected her objection. And subsequently, in appeal, I have challenged my lord. Annex 10, page 20. I am continuing till that only on ground that the respondent number 1 CDPO Gondia present and produce your file records regarding selection of Anganwadi worker in Puruna Anganwadi Center, verified the files and records. The CDPO stated that the recipient certificate of the respondent 1 has been issued by the Tahsildar Gondia. The respondent number 2 myself. The respondent 2 is a widow person and residing at parent village. On the allegation, no local inquiry by the CDPO has been done. From the above discussion, it is proved that the respondent number 2 originally belongs to Purunamang, where I have been appointed. And later she has got married in village Annapur. Accordingly, her residence changed on parent village to husband village. Her name has already placed in voter list of Annapur village. As per guidelines of selection of Anganwadi, outsider shall not be indexed. What happens? As per
so what are you challenging?
My lord?
What are you challenging?
I am challenging that order. Because here I have been.
There seems to be some confusion.
May we permit?
Yes. Just a moment.
Yes.
The first case, my lord.
First case is we don't know disposed of as
No.
no
These two
instruction.
cases are related, my lord. How it is? I'm just making a submission. The first case is that, my lord, with respect to the status, with respect to the residential certificate, one appeal was filed, and that appeal was dismissed. So challenging that one, my lord, the first case was filed by Arati Jana. On the
Because she lost in the appeal.
No, yes, she
Yes.
lost in the appeal. So, my lord, the residential certificate of the opposite party in Arati Jana's case, now that got confirmed in the year 2012, 3/5/2012. Another case, my lord, one appeal was preferred, Anganwadi appeal. That was preferred before the ADM. In that case, ADM had come to a conclusion while disposing the appeal that the residency certificate is not appropriate. In this case, my lord, the residence certificate, a separate case was filed before the competent authority. And that the authority also confirmed that residency certificate. But that was in the year 2012. Now, this order was passed in the year 2011.
So what will be the effect of, not pressing this first application?
Once this particular, this case is not pressed, my lord, then 3/5/2012 order, it will hold movement.
If that holds good, then what will be the effect of?
So automatically, my lord, the views of the ADM with respect to that she is not a member of that residence of that particular village. That
Yeah, what about the private opposite party in that case?
now her certificate, her residence certificate is now restored, my lord. That is to be governed in terms of the order dated 3/5/2012 because it is not pressed now.
So now if he withdraws or he says that no instruction, the writ application is disposed of, I think it should help you.
Yes,
Yes,
it will
definitely.
help you.
So why are you pressing your writ application now?
Because I have challenged the ADM order. ADM has passed the order by disallowing me to not to continue in the said post because I am not belongs to that residence. That was why I have
Consider
challenged.
that residence certificate.
Yes,
Now when that is no longer under the subject matter of challenge,
yes.
so I think it will have no impact on you.
And
Let us see in the first case, let us see the improved order
My lord.
for a moment.
Annex 10, page 20.
No, first case time first case time.
First case is a read we solve करना थी मुझे.
First case a copy of order miss certificate. No, certificate appeal.
Page note 20.
No, this is an appeal under the miscellaneous certificate rules. So how can that will come to me?
I think, my lord, that is why, my lord, I have also taken that it is not of assignment, my lord.
Yes.
But it has a direct bearing with this one.
So that can be.
It has a direct bearing with
That
this
can be kept for reference, but I cannot pass that order. You will have to. That order has to be passed by the assigned bench.
So if that will be, my lord.
So I'll do one thing. I'll just release it. You do the needful. After you do the needful,
Then this
you can obtain that order.
Yes, yes.
And then we can take up your
Yes,
next
yes.
application.
Yes,
Correct?
yes.
Item 1. List this matter before the assigned bench. Our matter today. As requested by Learned Counsel for the petitioner, list this matter 3 weeks after protocol.
29th August.
29th August.
Interim order may be continued.
Interim order to continue.
59 ହେଇଗଲେଣି।
No, point ଅଛି. My lord, your lordship, Hindu Succession Act, amendment of Hindu Succession Act,
ନାଇଁ, ମୁଁ
6
ଆପଣଙ୍କ
of
paper ରେ କହୁଛି।
parental ଏଟାକୁ change କରିବେନି residence ଟା. My parental residence will be considered, your lordship.
Today I have heard another matter on that, specifically on that issue. Yes, item 12.
Item 12.
Notice return answer from OP3.
Principal was noticed.
So there is some postal tracking report. Let us see.
The impugn
Item delivered, sir. Item delivered. Postal tracking report says that item has been delivered.
Yes. If the report says delivered, then it has been
Yes.
considered sufficient.
The postal tracking report indicates that notice on opposite party number 3 has been duly served, has been duly delivered. There is, however, no appearance.
It is in fact his order.
You are for the petitioner? Yes.
Under challenge.
Tomorrow, madam.
Yes?
Tomorrow, madam. Mr. Rathayan letters.
Kali habo. All right, let's this matter tomorrow as spread for.
Item 13.
Yesterday's matter. Yes,
Yes.
ma'am. Yeah, you were not there, that's fine.
Yeah, I'm sorry.
No,
Sorry, sorry.
Doesn't matter.
My lord, here the advertisement was made for some non-teaching post, including the post of junior technicians. The advertisement was made by the IIT
Junior
Bhubaneswar.
technician, yes. Terata post.
Terata post.
Yes.
My lord, I filed my application, which was accepted, and I was issued with the call letter. I faced the records of selection. Finally, I was selected and was issued with the order of appointment. Your lords will get at page 29, annex of 5.
Yes.
Thereafter, my lord, I was not allowed to join, despite my several visiting to the registrar. And he said that you come tomorrow, day after tomorrow, like this. For what? That is the reason for why I filed the other writ application that has been attached to this case. And there, my lord, the notice was issued. In that, after receipt of notice, my lord, my appointment has been cancelled. Your lords will get at page 34, annex 7.
Yes. Let us place it.
The undersigned, page 34.
Yes, yes, yes.
The undersigned director said that this institution has had inadvertently and erroneously issued an order of appointment to you for the post of
Offer of appointment. It's an offer of appointment.
offer of appointment to you for the post of junior technician under physical handicap category via our letter of even number dated 17 January 2014. You had submitted your application for junior technician for which there was no reservation under PH category, and the only reservation under PH category was for the post of junior assistant as per the above report advertisement. Your application that you belong to general PH category and recommended your name on that premises basis under PH category. However, to ensure proper scrutiny of the matter, you will called upon to submit your disability certificate from the competent authority. The certificate dated 15/3/2014 issued by the District Medical Board of Cuttack District relating the stated disability ex facie disclosed that it is issued to Ramshankar Mahanti, son of Prabhas Mahanti. Your application stated disclosed that you are son of Prabhas Chandra Mahanti. Only the difference is the pronunciation, that is PRA-BHA and PRA-VS. That is the Prabhas Chandra Mahanti. Thus, the institute therefore referred the matter to the district medical officer, Cuttack, who is the chairman of the district medical board of the Cuttack district for further verification. The chief medical officer Cuttack, via his letter dated 27/3/14, stated that from official record, it reveals that one disability certificate in favor of Ramshankar Mahanti, son of Pitavas Mahanti, had been issued on 15/3/2014. You had also furnished a declaration to the effect that in the event of any information being found false or incorrect at any stage, my candidature appointment is liable to summarily cancel, terminated without any notice or any compensation even later. Under such premises circumstances, your joining report was not liable to be accepted further in view of the lack of reservation under PH category for the post you applied for, that is junior technician, as per the advertisement herein above, and in view of the apparent discrepancies name of the father, which leads to non-confirmation of the genuineness of the certificate, the offer of appointment dated 17/1/2014 for the post of junior technician under PH category stand cancelled and withdrawn. That is the reason. I have filed the rejoinder affidavit. Your lordship have a glance on. So far as the letter of the medical board regarding the name of father is concerned, that was wrongly mentioned. I do not know under what circumstances that was produced before the authorities. However, your lords will get at page annex 10 to the rejoinder affidavit. They have clarified the situation that in continuation of this office letter dated 27/3/2015 that referred to in the cancellation letter. I am to inform you that one disability certificate in favor of Ramshankar Mohanty, son of Prabhas Mohanty, Mahanadi Vihar Colony, Noya Bazar, Kotak, has been issued this office by registration number 3619 dated 15/3/2014 with 45% of disability on orthopedical category. In the aforesaid letter, it was wrongly mentioned as son of Pitavas Mohanty instead of Prabhas Mohanty. So one of the reason that that disability certificate was issued in favor of Ramshankar Mohanty, son of Pitavas Mohanty, that has been clarified. Another aspect, my lord, only the pronunciation PRA BHA Prabhas and PRA VS Prabhas. That is the reason they have assigned. And so far as the reservation is this, they have now taken the stand after sitting for some days and after not accepting my joining report. Now they have taken a stand they have taken a ground in the cancellation letter that reservation was not for that purpose. Then for that purpose, your lordship have a glance the advertisement itself, my lord. Page 12, Annex 1. A and B, they have that vacancies they have shown. Just to the below of the table, the number of vacancies, the number of vacancies indicated above contain post reserved for SC, ST, OBC, OH as per the Government of India rules. The total number of vacancies may increase. Candidates belonging to reserved category are encouraged to apply for different category of post as given above. So they have specifically mentioned that the posts are reserved for all categories.
Come to the next below.
Next. One post is reserved for PH for junior assistant category, orthopedically handicapped. That is there, my lord. But prior to that, my lord, they said that the rules and regulation of the Government of India, so far as the reservation of for PS category is concerned, it is applicable. At that, my lord, that stand they cannot take. Now, my lord, in view of the, your lordship know that Supreme Court decisions, my lord, reservation, 3% reservation has to be in view of that Government Union of India versus General National Federation of Lights, 2013.
No, you should have challenged the advertisement.
No, because my lord, at that time they have specifically mentioned that.
No, where have they mentioned? They simply said number of vacancies indicated above content post for SC, ST, OBC as per GOIA rules. They are referring to the social reservation.
Yes.
Not the special categories. Special categories they have mentioned below. One post is reserved for physically handicapped OH for junior assistant. They confine it to junior assistant. Rightly, wrongly, whatever. You should have challenged that.
So that they have mentioned that one post for.
In spite of that, they have accepted your candidature, but rejected it basically on the ground that it is
subsequently they rejected when I approached this honorable court only because my joining report was not.
Let us get the response of Mr. Swine.
That is the.
So the advertisement has already seen Annexure 1, page 12.
No, you come to Annexure 7 straight away.
Yes, Annexure 7. That is
you say
yes.
You could have taken.
No, what happened? I am coming how it has happened. He has submitted his pursuant to the advertisement. He is completely aware of the fact that there is no reservation for the post of junior technician. He is applying for junior technician post, no reservation there for physical handicapped persons. But he has submitted his application clearly indicating that he belongs to physically handicapped persons. Okay. That has misled everything. That I have annexed as Annexure A to my counter. Page 13 of my counter affidavit. Annexure A by 1. A by 1. That serial number 8. Category SC, ST, OBC, PH general. Instead of writing general, he indicated PH. That means physically handicapped. That's misled everything, and his case has been considered as if he is a physically handicapped person. And accordingly, offer of appointment letter was issued to him. And when offer of appointment letter was, and this has been indicated physical handicap without any document with regard to that. So when offer of appointment letter was issued and it came for joining, it was document verification is required. At that time, it was detected as wrongly it has been issued. So immediately he was not allowed to join. And on the other, he was asked to submit if he has got a physical handicap certificate. That is also done on the basis of this. When physical handicap certificate is produced, that discrepancy in the name is also found. And that is one reason. And it was also found that physical handicapped persons cannot be
So
appointed.
these are two mutually contradictory pleas.
No, two.
You should have said, when, what, in your annexure 7, the letter,
Yes.
when you said that there is no reservation under PH category, since you have applied under PH category, which is not permissible under the advertisement, so you are not entitled. You should have stopped there.
They should have. But under the misconception, they have asked him to produce. And
misconception ହବନି ଆପଣ ସେଇଠି ବନ୍ଦ କଲେନି
ସେଇଠି initial physical handicap କରିଦେଇଛନ୍ତି.
Mr. Sai, what happens is, will estoppel not come into picture? You yourself relax it.
No, relax କିଛି କରିନୁ ଆମେ.
Then why did you accept the physically handicapped certificate?
Accept କରିନୁ ତ.
ତାକୁ ପଠେଇଲେ CDMO କୁ
ଯେହେତୁ ନାଇଁ ତାକୁ ଯେତେବେଳେ PH କାଟେଗୋରୀ ଫିଜିକାଲ ହ୍ୟାଣ୍ଡିକ୍ୟାପ୍ ଲେଖିଛନ୍ତି ତେଣୁ ମାଗିଲେ ତାଙ୍କୁ ମାଗିଲା ପରେ ଦେଖିଲା ବେଳକୁ ସେତେବେଳେ ଫିଜିକାଲ
scope for asking him. Where was the scope for asking him to produce a
there is no scope because
even because once you took the plea that it is contrary to the advertisement, there is no reservation meant for PH category, you should have stopped there. So
that we detected subsequently when he produced the
come to the letter, sir. Come to the letter. What does it say? It says both the things, which are
both the things. Both the things. Both the things. But when we asked him to produce the physical handicap, consider
CDMO clarification देले. से जो पितावास मानती नहीं है, से डाला प्रवास मानती. Clarified.
They have clarified. But when there is no, he himself is aware of the fact that no physical handicap quota is there.
Nowhere you have said that, but for the physically handicapped category, he would not have been selected. Otherwise, he has been selected. Shakira kotha kahi debe?
Physically handicapped quota selected because his mark is 10, but cut-off mark is 15. He has secured because he has secured 10, therefore he has selected. Physical handicap quota. Otherwise, general category se select होना.
Supreme Court तो कहले नहीं पता ना.
नहीं, Supreme Court.
But you cannot confine it to only one post.
No, one post.
One ये जो आपने केवल junior assistant पे रखी देले physical handicap.
हाँ. अन्य पे दरकार नथा बोले रखिन तो advertisement को challenge करना है. You also rightly said that he has not challenged the advertisement. And the principle of estoppel is not applicable to parent case at all.
No, but you are by your own conduct. You seem to have glossed over that mistake or glossed over that.
Quota ago detect la, quota pro detect la. ऐसी कोई कथा. At the time of joining, offer of appointment was issued only.
What is चाकरी पे वो
only offer of appointment was issued. If he has not joined, at the time of joining, all these things now.
Join नहीं vested right nice ऐसे जिनसे अच्छी, but you are the IIT.
IIT admitted. पाठो पढ़ा कथा था IIT serviceman.
The organization is a big organization.
So you have verified at that time. At that time, it is found that no advertisement was issued, and he himself committed the mistake.
I'm sure
he himself.
Mr. Swami, out of court, you will definitely agree that this annexure 7, this gentleman should not have written it.
से जो
किसी लिखा दरकार नथला जदि आपण कहै PH category रे आपण belong करनते भाई हेवी
because two reasons are there because two reasons are there they have written it because PH category PH category should deliberately why he has written they have calculated everything
देखिए
PH category he should not have written. And
is it possible to consider his case sympathetically?
I have also problem because it's not possible because there is no post. When advertisement is not there and he has misrepresented.
No. Then you have to clarify.
Yes.
He was selected for that junior technician.
He was selected junior technician post handicapped category.
No, let me complete. So he was selected. Rightly or wrongly, he was selected. He was never given appointment. He never joined. So was that post filled up by subsequent recruitment?
No post is there. Physical handler, there is no post.
Physical handler
filled up.
You take instruction then.
Because in law also
to fill up that post.
In law also he has got no right to join.
But that's solid. That stand you have taken, that is all right. That point is taken. But I would like to know whether
even if not filled up also,
is it possible to consider his
because his case is to consider as general category because he is not physical handicap. Advertisement general
you should have, instead of stopping there, what you or your register has done, He has gone into the merits of the disability certificate, sending it to the.
ସେ ଯୋଉଟା କହୁଛନ୍ତି that is correct, but the fact remains he is on a physical
କୋର୍ଟ ଦେଖିବେନି
ଆଜ୍ଞା
ସେ କଣ୍ଡକ୍ଟରକୁ କୋର୍ଟ ଦେଖିବେନି
ସେ କଣଟା ଆମର ମିଷ୍ଟେକ୍ ହେଇଛି ବୋଲି to have rectified that. ଆଉ ସେଇ ଟାଇମରେ ଦିଟା ଯାକ ଜିନିଷ ସେ ଦେଖିଛନ୍ତି advertisement ନାହିଁ physical handicap କୋଟା and also ଯୋଉ document ଦେଇଛନ୍ତି that is also defective.
I'm just thinking aloud that if I can adjourn it to next week so that in the meantime you can obtain instruction whether it can be favorably considered in view of the clarification issued by the CDMO that junior technician. If it has
physical handicap ତ ନାହିଁ ଥାନ୍ତା ତ consider କରିଥାନ୍ତି even if defective certificate ହେଲେ ବି କହିଥାନ୍ତି consider କରନ୍ତୁ ଯେହେତୁ ନାହିଁ ତେଣୁ ଥାନ୍ତା ତ କରିଥାନ୍ତି physical handicap କୋଟା ନାହିଁ.
Is concerned, Mala, they are bound to keep.
I'm keeping it to next week. This has been heard. The understanding that next week there will be no hearing. I'll just close it because of other judgments are there. So I'm just keeping it to next week.
Well, apart from that, Mala,
You don't have to obtain any instruction. Hearing is concluded.
No, hearing ଥାଉ ମୁଁ ତ instruction
Only one line, my lord. They have given this chart of selection, recommendation of selection committee. Well, they have recommended the name of 1, 2, 3, 4, 5, 6, 7, 8 persons. Out of 8 persons, my serial, so far as the mark secured is concerned, I am is at serial number 3.
Where are you reading from?
Page 25 of their counter.
Annexure ta kaun?
Annexure B by 1.
B by 1, yes. Page 24.
Yes, page 24. Sorry, 25. Ramshankar Mahanti.
Serial number 6.
Yes.
Serial number 6.
Serial number 6.
He has secured 15 marks. General category last cutoff mark is 20. Just below it is written general category cutoff mark is 20. SC ST general category is 10.
1, 2, 3.
So because secured 15 and cutoff mark was 10. General category cutoff mark is 20.
Correct. Heard in part.
Here he has secured.
I'm keeping it to next week then. Heard in part. Let's this matter next week. But no further hearing will be necessary if you can obtain any instruction on it. Otherwise, I'll close it on that day. Next week, I'll close it.
No, Rosip is asking whether you can accommodate or not. I will obtain instruction. Let me hard on that. That I will write some decisions that principle of estoppel is not applicable to the tax.
Certainly, certainly.
Item 14.
Item 14.
Balaram Gopal. So not keep it to 31st. Next week.
Next week, though. Next week, 31st question. 1st August.
Another matter.
Mr. Lanka, Mr. Swami has some difficulty on first. So we'll take it up on first for 8th August. 8th August. Yes, Mr. Das.
My leave of your lordship. My grievance is annexure 9 at page 35 and 39 of your lordship brief. Before I take your lordships to that.
Annexure 9.
Annexure 9.
Yes.
Annexure 9.
Annexure 9 is a representation.
Is my representation, my lords. Then annexure, then I take your lordships to annexure 9. My representation was forwarded to the authorities. They did not consider it. Then I approach your lordships by annexure 10, page 40. Then your lordships direct and in such type of.
It's a long further affidavits of.
Even if Mr. Das, even if it is
covered by ignorance with all such papers.
No, Mr. Das, even if it is a peanut, the kernel has to be broken open to bring out the seeds.
Oh, that is
and
true.
put in the mouth.
True.
Isn't it?
But in that regard, my learned senior is a squirrel.
No, not a squirrel.
He doesn't need a hammer to break.
Anyway, as requested by Sri Das Learned AG, list this matter. We'll take it up next week then.
Yes, next.
On 1st of August.
I will be retiring in the month of October.
I will take it up on 1st of August.
But before your lordship goes to the next item, may I take 1 minute? Why my anxiety is here? This is a very small, my prayer is rather innocuous. Anganwadi supervisor promotion. Before me, 10 persons were promoted in regular scale. After me, 9 persons were promoted in regular scale in which there were juniors to me. I was promoted to the post of Anganwadi supervisor with a consolidated scale of pay. Whether that can be permitted.
I think they have a regular scale.
Yes.
They have a regular scale.
Yeah, but the difficulty with the present petitioner, he had undertaken at the time he was
That
giving
has long
promotion.
been settled by Honorable Supreme Court. My undertaking cannot upset the process of law.
That of course is there.
And my juniors have been given, and I have been have made to be satisfied with the paltrism against a substantive vacancy which was created in 1997. And before me, there are also incumbents. They enjoyed regular scale of pay. Now I am there suffering from 2010 with a regular with a consolidated scale of. That is only my grievance. If your lordship brings it next week, I will say.
1st of August.
As your lordship please.
Yes. Item 15.
May I pray, may it be treated as a heard in court, if it is then permissible before your lordship's bench. Grateful.
We take up limited part-heard matters, so
Grateful.
everything has to be adjusted according to a ever revolving wheel.
As your lord. Grateful.
Yes, yes, Mr. Nagar.
I'm for the OP number 5, my lord.
Who's for the petitioner? Jagabandhu Sahu. CORAM Meher. We'll pass it over, Mr. Nanda, for some time.
Tomorrow, if it can be taken up.
Tomorrow.
Tomorrow. A small matter.
All right. None appears for the petitioner. Learned counsel for the opposite party is present. Let's this matter tomorrow.
Grateful, ma'am.
Item number 16. Well, in this case, the lordship had directed the collector to conduct an inquiry and to conclude the same within a period of 8 weeks and to submit the report by 17th of June, my lord. And thereafter, my lord, there was a mispetition for taking into consideration that at the time of inquiry, that both the parties should be heard. Respective parties should be heard, my lord. And that was passed in the month of June to 20th June, my lord. So today, my lord, I contacted them, and actually, my lord, sorry to say, my lord, they have considered that, my lord, 8 weeks. I may be permitted not to consider with any other things, my lord. May I pray, my lord, this matter may be taken up by granting 3 weeks time, my lord, so that they will conclude it and they will submit. That 8 weeks, my lord, wrongly on the basis
What
of
is it, Mr. Mishra?
that is on the only 3 weeks, my lord.
Sri Yashan Patnaik Learned AGA submits that as per instructions received, the inquiry has not been concluded as yet.
Yes.
He prays for 3 weeks further time. Is this matter?
29th August.
29th. By that time, my lord, prior to that matter, most of it.
There is no transfer of that collector.
Transfer of the? Transfer of the?
Collector. Somebody is going to transfer the collector, therefore there has to be transfer.
Yes.
Item number 17.
May I please, your lord, regarding the appointment of Anganwadi worker,
Yes.
the petitioner and difference between petitioner and OP number 5 whose appointment is under challenge. The OP number 5 was a Anganwadi helper.
Somebody is appearing for the opposite party?
No, I am for the petition.
Anybody is appearing for the opposite?
No.
Notice was issued sufficient?
Yes.
Let me see whether the notice has been sufficient or not.
No mention in the.
No. Office note does not indicate whether.
She will be the person affected.
Again, notice was issued. Now, AD from OP number 5 received after service. So you are there for the state?
Yes.
So notice is complete. Service is complete.
Yes.
What are you challenging?
Lord, I am challenging the appointment of OP number 5. OP number 5 was working as a Anganwadi helper in the same revenue village in the another Anganwadi center. That is the crux. The government guideline says the Anganwadi helper can be appointed if she has worked for more than 5 years. That is not in dispute. My concern is the learned sub-collector has rejected my appeal on the ground that relying on the clarification letter issued by the district social welfare officer under Annexure 10. Yet the same Anganwadi helper of the same revenue village can be engaged as a Anganwadi worker in the another Anganwadi center. My submission before your lordship is the district social welfare officer has no power to clarify the position of given by the commissioner.
Let us come to the guidelines.
My lord. Annexure 4.
It says Anganwadi work helper and work organizer, if having the requisite qualification and are found to be suitable, shall be engaged as Anganwadi worker.
Yes, sir.
Provided they have worked for more than 5 years. It
Yes.
does not say anything with regard to the from which helper, which center he must have been a helper. Say clarification or not.
I have also filed a rejoinder affidavit clarifying that position, that has not been clarified. And it is admitted fact that I belong to the service area and
No, Mr. Naik, I'll tell you one thing. When nothing has been provided in the guidelines,
my lord.
specifying that the person who is working as a helper in the same Anganwadi worker can be considered as for engagement as Anganwadi worker, you cannot read anything into it by saying that it has to be
Yes.
from the same Anganwadi center.
Yes. My lord, my point is that he was there are 2-3 Anganwadi centers in a revenue village.
Yes.
And I belong to Good Malisai Anganwadi Center, and the OP number 5 belongs to Good Telisai Anganwadi Center. She was.
You are also working as a helper.
No, I am a fresh candidate. I have secured more marks in the matriculation. That is my stand. But she works as a Anganwadi helper in another Anganwadi center of the same revenue village. Well, my submission that she was working as a Anganwadi helper in this other revenue, other Anganwadi center. So she is not eligible to get preference over me, because if she will not get preference, then I have a right to select it, because I have secured 51% marks and she has secured 31% marks.
Yes.
In fact, in the impugned order itself, the ATM, the sub-collector Balesur has said, in view of the above discussion, he has discussed about the experience of the present selected candidate.
Yes.
And perusal of relevant documents and the proceedings of the selection committee meeting on 8/9/2016 and the relevant papers appended, that is at page 59. Papers appended to this case record, I am of the opinion that the selection committee held for selection of Anganwadi worker, Good Malisai Anganwadi Center, have followed the government guideline and considered the experience of Rebati Behra as Anganwadi helper in Good 4 Anganwadi Center have selected. So her selection has been only on the basis of not only her qualification, but
no, what the petitioner here says, Mr. Das, is that she has to be, in order to invoke that particular clause of the advertisement, she has to be a helper of that Anganwadi center, of which the post has been notified. I don't find any such, though I was also of the same opinion some time back, but I find from the clause 4, come to clause 4 of the guidelines, which is at page 61 of your brief.
Okay, read it.
Yes.
Yes, Anganwadi helper and organizer, if having
Anganwadi helper of the same Anganwadi center only
ନାଇଁ ସେମିତି କିଛି କ୍ଲାରିଫିକେସନ ନାହିଁ, ଡାଇରେକ୍ଟ ନାହିଁ।
ଯଦି ନାହିଁ
କିନ୍ତୁ ତାଙ୍କ ଫରରେ ବି କିଛି ନାହିଁ ଯେ ଅଦର ଅଙ୍ଗନବାଡି ସେଣ୍ଟର ହେଇଥିଲେ
ନାହିଁ ମାନେ ହେଇଗଲା ତ ଓପେନ ହେଇଗଲା, ଆଉ ନାହିଁ ହେଲା ମାନେ ତ ଓପେନ ହେଇଗଲା ନା, ଆଉ କ୍ଲାରିଫିକେସନ ବି ଦରକାର ନଥିଲା। And that clarification obviously will never override the whatever, they never override the guidelines, but if we read it plain and simple, the clarification is in conformity with the guidelines. It simply says Anganwadi helper.
That
So
is there.
on the principle of interpretation of statutes, can we add anything to it? Can we qualify that word? Anganwadi helper एतिकी ये जो दीटा word रहला ताको आमे तादर addition किछि करि परिबे की Anganwadi helper belonging to the same Anganwadi center आमे मनोरानी की तादर जोड़ी दे परिबे की
Now here is a case, she does not come within the service area.
That's a different matter. That is a different matter. Service area and all to that's a different matter altogether.
Yes.
That is another requirement.
Yes.
Which is at again that is at each village Anganwadi center area from women residing in the said village. When there is a comparison between two women of the same village, then the person who is residing within the same area has to be considered.
Yes.
That is why the condition.
Yes.
So on that, what is your reply?
In paragraph 6 of the counter affidavit has been filed.
Yes.
1 to 4.
Yes.
They have said that at page 2, it is not a fact that the sub-collector Baleswar on flimsy grounds rejected the representation of the petitioner dated 25/11/2016. Passed the order of SSW miss case number. The order passed by the sub-collector Baleswar in SSW miss case is true, just and proper. It is a fact that the appointment part number 5, Srimati Revati Behra, had worked as Anganwadi helper in good 4 Anganwadi center under the ICDS project for more than 5 years. And as per revised guidelines issued by the government in Women and Child Development Department, Odisha, an Anganwadi helper having requisite qualification of HSC passed and worked for more than 5 years in any Anganwadi center within the same revenue village where notification is published can be selected as Anganwadi worker.
8% भी अपन ऐड करछन.
Yes, in any Anganwadi.
8% भी अपन ऐड करछन. So if now another interpretation can be made.
Sure.
If this clause कहते थे ना clause 6.
Clause 4.
Clause 4 is read along with clause 1, then it will only mean the same area. You have to make a harmonious reading, because being a resident, given the scope and object of this scheme, it is desirable that a person belonging to the same area is engaged as an Anganwadi worker.
Same service area.
If that is there, if we look at only at 4, then clause 1 becomes redundant. So they have to be harmonized. They have to be read together. Clause 1 and clause 4. Then what will happen is the effect is a person working as Anganwadi helper in any Anganwadi center of the same area alone can be given a preference. Here what has happened is she belongs to the village. Undoubtedly, the petitioner also belongs to the village.
Same village.
So clause 1 has an overriding effect given the nature of the scheme. Given the nature and object of the scheme, clause 1 would have an overriding effect over clause 4.
Yes.
So she has to be a resident of the same service area, which also would mean that she has to be a helper of any Anganwadi center working, existing in the same area. In what has happened in this case is they have only looked at the helper part and granted her, given her preference, ignoring the fact that she resides in another service area. So that clarification has not been issued. I'm keeping it part. Do you please address the court on this issue?
Yes.
Yes. Heard in part. The parties are requested to address the court as to the effect of a harmonious reading of clause 1 and clause 4 of the revised guidelines dated 2/5/2007 vis-a-vis the scope, object and intent of the Anganwadi scheme. List this matter on 22nd August. Mr. Naik, please find out if you can.
Yes.
Can you find out if you can find out any, judgments? Or yes.
Item number 18.
But in this case, my lord, as per your lordship.
Let me read the.
Yes.
Is the district education officer present?
Yes, ma'am.
Yes. Yes. Did you make that reconciliation? Did you reconcile the records with the OPEPA?
As per the instruction of my lord, I have gone to the SEPA and got some information, but still that is not clear. And I need some time, sir.
No, you, because it says that Mr. Kora has also applied for the said post during 2011. Yes. So what is your?
Sorry. May I assist?
Yes, please.
My lord, in fact, my lord, the DO had exercised, the contrary his own exercise, my lord, and he had approached the authority, my lord. And he got the document in writing even, my lord. Now, already there is an admission before your lordship with an affidavit to that effect that the petitioner has not applied. And there is a document saying that, my lord, in the year 2011, the petitioner had applied. So, my lord, I was also going through different other documents because this document was of 2011, the recommendation, what it has been referred to. And there are subsequent correspondences of 2017 after the law department's opinion, my lord, wherein there are candid admission in the file, my lord, that the petitioner had never applied. After there was a fact, the same authority had asked for a report from the DPC, and the DPC had conducted thorough search, and after conducting the search, my lord, they have reported that. I think, my lord, if this matter can be taken up next week, my lord, I will go through the same, and because we are discussing, a detailed affidavit can be filed, so that there will be no.
All right. I am willing to grant you that time.
Yes.
But how do we go forward?
No, that is what, my lord.
How do we go forward?
Yes, ma'am.
This person has been suffering for so long.
My lord, that is what, my lord, that now, what is the question, what is the extent of suffering, my lord, for the petitioner, my lord? In respect of 2000.
What is your name? Santosh Kumar Raut. Shri Santosh Kumar Raut, the district education officer, come DPC, Samagra Shiksha Kotak is present, as directed. He requests for some more time by submitting that he has already held several discussions with the officers of OPEPA.
OSEPA now.
OSEPA नहीं, OPEPA में लिख दी थी, अच्छा OSEPA. But the query posed by this court is unable to be answered with precision. Having regard to the fact that the petitioner is appearing in person and is a physically disabled candidate, this court is ordinarily not inclined to grant further time. However, in the ends of justice, for the ends of justice, one more opportunity is granted to the state to clarify the position as per order dated, as indicated in order dated 11/7/2024, comma, if necessary by filing an affidavit. If necessary by filing a comprehensive affidavit. What can be done here? I mean, there are two conflicting documents. One says that he has applied, and obviously he'll say that I have applied.
And my lord, the previous decision of the honorable court says that, my lord, challenging that advertisement, my lord, he had approached before this honorable court.
True.
So he had not.
No, that is true. But if there is material to show that he had, irrespective of his challenge, if he had applied during 2011,
my lord, we will face the facts.
All right. Let this matter on 8th August. 8th August. 8th August. Affidavit, if any, be filed in the meantime. The personal appearance of Mr. Raut is dispensed with for the timing. However, he shall appear in person with the affidavit, if any, on the next date. Yes, you got the message. Do whatever is within your. Yes. Yeah.
Item 19.
ଯାହା ଆଇନ ଅନୁଯାୟୀ ଯାହା ହେଇପାରିବ ସେଥିରେ ଆମେ ଚେଷ୍ଟା କରିବା। ଆପଣ ଖାଲି ଚାହୁଁଛନ୍ତି ବୋଲି ହେଇଯିବ ସେମିତି ନୁହେଁ, ଦେଖିବା ଯାହା ଆଇନ ଅନୁଯାୟୀ ହେଇପାରିବ ଚେଷ୍ଟା କରିବା। Yes. Item 19.
I'm just now received the copy of the rejoinder. I'm appearing for the opposite part number 5. I've just now received the copy of the rejoinder.
Mr. Mapata, you waited for the 11th hour to serve a copy of the rejoinder?
Just now I saw this.
No, no, that is a good way.
No, it is final.
That is a good way of seeking adjournment.
No, I don't say that should be adjourned.
No, we'll adjourn. No.
Obviously.
Copy of the rejoinder filed by the petitioner has been served upon
Copy number
counsel
5.
for opposite party number 5, who wants some time to go through the same and to make her submissions. Is this matter next week, Ashwin? Next week?
1 week after.
Nah, next week.
Next week.
These are 2023 matter, all right, 1 week after.
8th August.
8th August.
Much obliged.
Item 20.
May I please your lordship? My lord, here lordship, I challenge the order issued by passed by the ADM Koraput under Section 4 and termination order.
Just a moment. The postal tracking report indicates
My lord.
that notice on opposite party number 5 has been duly delivered. There is, however, no appearance. Yes.
Here, your lordship,
Yeah, 2024 matter, we'll take it up on some other day.
some other day, but my lord, how the notice has answered, written answer, because she's working.
Notice has been returned unserved. No, coil पर एक ना, the notice has been served.
My lord, sorry. But it is noted as some other.
No, it may have been noted, but the postal tracking report shows that it has been served.
My lord.
What interim order do you want?
No interim order.
All right. Let's this matter
Right, 29th August.
on 29th August. Yes.
That aguroti के तरफ बोलता
24 2024 matter है. 2010, 11, 12 matters सब चली. कौन करिए?
29th, my lord.
Item 21.
On behalf of Mr. A.K. Ponda, my lord, no instruction.
No instruction dispose of.
Obliged, my lord.
Item 22.
ये काली थी लगी. 22 था. Item 22. देख लो काली थी लगी.
Here the IIC BDPS was directed to sub-copy, but he has informed to this our office that he could not be available in office. From the local source, it is ascertained that he is staying outside since long. Tried to contact him over mobile phone number that has been given, but he did not respond.
Okay.
This has been the information supplied by the IIC BDPS.
United State Council submits that despite repeated attempts, the notice could not be served by the IIC
BDPS
on the opposite party, as he is residing outside. He is residing in some other place. Stop. He also did not respond to the phone calls made by the IIC. List this matter 4 weeks per.
5th September.
On 5th September, further attempts be made by the IIC to serve the notice as directed. Yes.
Item 23.
Pardon, my lord. Item number 20, your lordship. Till now, they have not submitted any counter.
Well, let's say item counter.
Then I will file the.
Yes.
Here, your
Right, 23. The earlier one, Madam Subhalakshmi Madam was appeared. And next time, without informing the client, my name is. So I instructed, advised him to give the brief to the showroom. However, she agreed to for the conciliation. May it be sent to mediation.
You are Mr. Patnaik appearing for whom?
Opposite party husband.
Yeah. What do you say, Mr. Mahanta? Let it go for mediation. Mediation, sir. Mediation order टा कर दें कि करन तो केबे को
Hyderabad ticket long.
26 September.
आउट के लॉन्ग करना
26 September.
लास्ट अडू करो सितंबर
26 September.
26 September.
Item 24.
May I please, your lordship, my lord? The wife is the petitioner in the present transfer application and Marital.
24 also your matter, Mr. Patnaik.
And meanwhile, the mediation has been failed.
All right.
So my prayer,
difference
report of the mediator indicates that mediation between the parties was unsuccessful. Yes, what has happened? So will
Photogroup Bhubaneswar. Husband is working at Bangalore, and more so he has a bedridden father.
So if the Kotak Bhubaneswar, we will pay the cost accordingly. I have filed my show course.
No, no, Mr. Proceed, normally I don't allow from Kotak to Bhubaneswar.
Right.
Vice versa, I never allow. Because either at Kotak or at Bhubaneswar, you can, and I will also grant opportunity to appear through virtual mode.
Because my lord, the question is like.
He is
this,
also
my-
going to Women's Commission. Good.
Because the question is like this, my lord. The distance is not a material fact, my lord. No male members are available with the wife, my lord.
No, no, I will permit her to appear through virtual mode.
Virtually mode, my lords, there are some.
And unless absolutely necessary, her personal attendance will not be insisted with by the court. That I will virtually mobile पे appear करियो कौन सी बात है?
Because my lords, there will be some difficulties.
What difficulties?
At the time of trial, my lords. Because instantly I want to confront one document or the opponent side wants to confront some documents.
Virtual mode रे सही तो that objection has to be taken. अब कौन करा जो confrontation कौन इतना अच्छी गोटे civil suit?
Because now the question is divorce has been filed by the husband and two proceedings are here.
You are residing in Bangalore.
My lord.
How does it matter whether it is Kotak or Bhubaneswar?
My lord, is Bhubaneswar. My father is bedridden.
So what?
Complete bedridden.
So what? You are in Bangalore.
But
Your father may be.
I used to come. Bhubaneswar. So and I am ready to pay the cost of the.
Two proceedings are pending. One proceeding, one Indian case is.
I will grant you virtual mode.
My lord.
The petitioner wife seeks transfer of such and such proceeding from such and such court to such and such court. Therefore, transfer is made on the ground that the petitioner is residing at Cuttack. And it would be inconvenient on her part to travel to Bhubaneswar to attend the court on the dates fixed. Considering the relative inconvenience, a virtual mode.
Item 25.
Item 25, petitioner is wife. Other side is already interactive.
Yes.
May I pray for a mediation?
I mean mediation, but other side is not there, so
Last time also he was not there.
I am ready to pass that order, but it should be in presence of the other side counsel. Unilaterally, it will be difficult. You inform me, I am passing it over. If you can inform the other side counsel, all right, pass over.
Item 26.
I'm for the opposite party husband, man.
Yes.
My lord, I pray for next week, my lord. I lost my file, my lord.
All right, next week I spread for.
Item
Spread for
27.
by counsel for the opposite party.
Oblige.
Item 27, 27?
27.
27. All right, pass over.
Item 28. Petition is the wife, my lord. It is not back.
Item delivered. The postal tracking report indicates that notice from opposite party has been duly delivered. There is however no appearance. The transfer application is therefore taken up for hearing. Go to
item 26 to interim order cut.
interim to continue 26 seconds. From Bhubaneswar to Khordha, why?
And other proceedings are pending. And my lord,
Where have you said that?
my lord, I have annexed the annexed to 2. My lord, 125 petition is also pending, my lord. But
The petitioner wife seeks transfer of CP number 691 of 2023 from the Court of Learned Judge Family Court Bhubaneswar to the Court of Learned Judge Family Court Khordha. Prayer for transfer is made on the ground that the petitioner is residing at Khordha and 2 other proceedings are also pending before different courts at Khordha. Considering the above facts,
Item 29.
After the petitioner wife.
29.
Yes, madam. Residing Rourkela. Case is at Hon'Ble. Also 2 cases are in Rourkela. Is appearing.
Yes, Mr. Mahapatra.
Today only I have taken instruction from my conducting counsel at Hon'Ble. As far as the instruction, Lordship, this case is posted for pronouncement of judgment for coming 27th of July, Lordship.
ଆଉ କଣ ହବ?
ଆରମ୍ଭ notice ତ ଲାଗିଥିଲା kindly notice.
You do one thing, you take instructions in this regard regarding status of the. You will ask your client or କଣ?
appear କରିନି ସେଠି।
ଆପଣ ପଚାରନ୍ତୁ ଆପଣ ଏକ୍ସପର୍ଟ ହେଇଥିବ କଣ ହେଇଥିବ?
ହଁ ଏକ୍ସପର୍ଟ ହିଁ ଯିବ।
ଏକ୍ସପର୍ଟ ହେଇଥିବ। ଏକ୍ସପର୍ଟିଜ
ଏଇଠି ପେଣ୍ଡିଂ ଥିଲା ପରେ ନୋଟିସ୍ ପାଇଲା ପରେ ବି ସେ ଇନଫର୍ମ ନ କରିକି ସେଠି।
ନାଇଁ ଏକ୍ସପର୍ଟି ଯଦି ହେଇଥିବ ତାମାନେ ଆମେ ଆପଣ ନୋଟିସ୍ ପାଇଥିବେ ବୋଲେ ନୋଟିସ୍ ସଫିସିଏଣ୍ଟ ହେଇଥିବ ବୋଲେ ଏକ୍ସପର୍ଟ ହେଇଥିବ ନା। So you find out. I'm keeping it pending. Case can be transferred. It is not that. ଗୋଟେ 3 week time.
29th August.
Let this matter on 29th August. The parties shall apprise the court about the present status of the case in the court below.
Item 30.
Grateful.
Notice was issued, previous date notice was issued.
ଆମର ରିକ୍ୱିଜିଟ୍ସ ଫାଇଲ କରିନଥିଲେ ଶୀଘ୍ର
ସାର୍ କରିଥିଲି ଯେ ରେଜିଷ୍ଟ୍ରି ପୋଷ୍ଟରେ କରିଦେଇଥିଲି ଅର୍ଡରଟା ଶୁଣି
Requisites as filed be accepted and notice be issued fixing a short returnable date. List this matter September karo.
12th September.
On 12th September adjournment.
Item 31.
I am appearing for opposite party. Today I am
Manmoy Kumar Das has entered appearance for the opposite party. The filing Wakalatnama in the court. Same be kept on record. His name be reflected in the cause list. Yes, Mr. Mathi.
See here the petitioner, the wife seeking transfer of the case from Lord Judge Family Court.
Mediation, Jibu?
So,
I
directly to
suggest-
appear before the Family Court, Barampur.
Bangalore ରହୁଛନ୍ତି ଏଇଠି ହେଇଗଲେ ଭଲ।
No, ଏଠି
Fine,
ତ
sir.
lady ଟା
Because
You will pay money.
one day ଯଦି mediation if my
No. You will do it at Cuttack, but you will pay her to and fro travel expenses. Actuals, bus fare.
if my lord permit me for one line, my friend filed this application TRP for transfer of a 13B application. 13B was filed by both the parties.
Now mediation कौन होता है?
If at all you are interested, you join in that one day it will be completed in an hour.
One day रे केमती completed? 13B one day रे जो सबो केस रे कौन ସେମାନେ सबो केस रे कौन ସେମାନେ cooling period टा वर्क कर दे परिवे?
नहीं cooling period सच्ची।
तो सही है
हाँ।
पहले मिस्टर मानती why transfer?
No. You must kindly see.
Marriage
The appearance of the notice was issued. The appearance is the 18/5/2024.
No, marriage date.
Cooling period टा क्यों चला था?
Marriage date.
अगर 6 मास में
17 the marriage.
The cooling period can also be waived
Let's see.
under certain circumstances. Can it not?
So notice was service and the direction was
File is January.
given to 18/5.
No, Mr. Mahathi, I am willing to keep it pending, but if it's a 13B application.
13B, that I am submitting.
Because some pretext of the same laws, you can see
Yes, sir.
the other matter is given.
Subject to his acceptance. If one day
The one day should be directed to appear before the Lord Judge
जोड़ी अच्छी सिटी
Barampur
कोर्ट अछि
नोएगढ़
Barampur mediation center.
mediation
both of them are-
Even if my friend is
they are working both of them are
just both of you have decided you have filed a joint application.
yes
Isn't it?
Here now I am disputing the application itself, Lordship.
You are disputing that application. You have not.
I have no more interest to proceed with the
my
joint
instance is
application.
that amount is disputed.
Then you have to appear before that court and file an application.
No, you do know within one day that will also come
You file that, so that application will be rejected. Why transfer it then?
rejected. That is
Why transfer it? If you say that you are no longer interested, that is why the cooling period was given. Cooling period concept is only for that if somebody party changes his mind.
No, sir, तो अभी recently hitla तो से period
they are
का नहीं. Even in number of occasions, the opposite party also appear in the house of the petitioner.
Please understand the situation. If your client wants to withdraw from that application, then you have to make an application before that court and it will be withdrawn. That will be matter. Why transfer?
you are free
So I'm just adjourning it. You take instruction from your client.
I am suggesting subject to my friend's action.
Sri SK Mahathi, 11 council for the.
One suggestion. If at all there is a chance of settlement or either way. So one occasion in the mediation here also can be possible. My instruction is that amount is disputed. She wants some more. It was only 1 lakh was there. So therefore it is all these things. So in one occasion, it can be settled. If amount is only disputed, therefore I am suggesting my lord can suggest one in 971 that can be done. Here, my friend will be there and both the clients will be there.
What do you say?
See, appeal husband,
Any day.
there is no difficulty. Any day,
Any day, your lordship.
before the act, Barampur,
One chance
before the
here.
Lord Judge family.
Barampur again difficult.
No, see,
Both of them are working at Bangalore. So Bhubaneswar asigi airport
Sir, Appa Darabi, they have.
Dijon jaka Bangalore asigi. So therefore I
No,
am
no, he is not, he is in village, Lordship.
my instruction.
The petition is in village, not at Bangalore.
Any place subject to us.
No, I'll hear this on merit. I'll hear this on merit, whatever.
Lordship.
Yes.
Here, Lordship, the petitioner is the wife seeking transfer of the case on the ground that there is no such male member as available to accompany with the petitioner to appear before the Lord Judge Family Court, Nayagad. And also there is long distance from the parental house of the petitioner. There are no other female members also available accompany with the petitioners. Here also when the notice was served to the petitioner came to know that on some false pretext the such a petition, such a case has been instituted before the Lord Judge Nayagad. Lord Judge Family Judge Nayagad. The petitioner seeks transfer of the same in view of the judgment of the Honorable Supreme Court. So may kindly consider the same and transfer the application of the wife, Lordship.
The cost of repetition, it's a application on 13B. Both the parties have agreed and filed their application. So the question of transfer comes if it is a regular trial, my lord. So if it is 13B, my lord, one evidence in one day. So that transfer is not at all required, my lord. That is the submission. If my friend's client is interested for disposal of the matter, it can be done. I will cooperate.
You are one of the applicants.
Lordship.
Knowing fully well that you are residing at Barampur, you filed the case at Nayagad. You could have filed it also at Barampur. You did not do that. You filed it in Nayagad and now you should seek transfer. No, not allowed.
Lordship, kindly see the annex, sorry, on page 16, Lordship.
Yes.
By Annex 1, I am disputing the signature itself in the affidavit, the document.
So approve that court. File an application.
I am also, now I am interested to withdraw the application.
So you filed an application before that court.
Lordship. On such liberty, Lordship.
Yes.
Dispute the same.
Liberty darkar nahi, but the petitioner wife seeks transfer of CP case number 40 of 2024 pending in the Court of Learned Judge, Family Court, Nayagad to the Court of Learned Civil Judge, Senior Division, Purushottam. Therefore, transfer has been made on the ground that the petitioner is residing at Purushottam, which is far away from Nayagad, and therefore it would be difficult on her part to attend the court at Nayagad on the date of posting of the case. Shri M.K. Das, learned counsel for the opposite party husband, submits that the application in question being filed under section 13B of the Hindu Marriage Act was application application which signifies the mutual consent of the parties to separate. On such understanding, the petition was filed jointly with the knowledge of the petitioner. Shri S.K. Mahathir and counsel of the petitioner, however, submits that his client has subsequently decided to withdraw from the said application. Considering the submissions as above and taking note of the fact that the petitioner herself wants to withdraw from the joint application, the transfer application is disposed of, granting her liberty to approach the court below by submitting appropriate application. Yes. Shut up.
May be fine. In item 8, where your lordship directed personal appearance of the ADM, may I pray this may be uploaded today?
Yes,
So
yes.
that I can,
Item 8 तक संग संग upload करो. Yes, yes. It will be done immediately.
so that I can intimate him.
Item 32. 32 रे की question?
My lord,
Yes.
I am the petitioner wife, my lord.
Let us see whether notice has been served or not.
Yes, issued.
No, you have to take fresh notice. The postal tracking report indicates that the addressee cannot be located. Let a copy of the transfer application be served upon learned State Council, who shall cause the notice to be served on the opposite party through the IIC of Kothana. So, no, Dabidwar Police Station. No, Dabidwar, Jashpur Town Police Station. Jashpur Town Police Station indicating that the matter shall be taken up for hearing on 29th August. Place this matter on
Extra
29th.
copy, makes.
Extra copy.
Ultimate.
Ultimate order to continue. So now we'll begin the hearing matter. So
Item number 38 can be taken up next week.
item
38
এই লিস্ট কোন হইছে
can be taken up next week. Already I'm not.
All right. You want next day, next week?
Next.
All right. This is this matter next week. That's great for that. Please. I am trying to follow Justice PC Naik.
Yes, I was just talking about that.
Yes.
This is a second bill in which I have, and also I have filed my written note of submissions.
This has been admitted.
Admitted, it was being heard by the earlier bench from which it has been approved. And
yes,
during the hearing, it has come. May I place that written note of submissions
Yes.
on record?
Yes. I will just look at the whether the learned appellate court is justify the boundaries which are mentioned in the schedules of the case of Order 7 Rule 3.
Pardon?
Order 7 Rule 3 is involved here. Identification.
Identification, here is a commissioner was also by this demand order of the Hon'Ble court. Commissioner has submitted a report. Again, the appeal has been went against the court.
Yes. LCR नहीं से नोट दीजिए
नोट टा खाली दे दे चलो स्कैन हेजिंग में जाएगी नोट टा
कौन सा कौन
कौन the RSA has been filed challenging the judgment dated 38/2018 and declared 6/9/2018 of the Court of the District of Ganjam, passed in RFA number 104 of 2010, allowing
yes,
allowing the same, and in the process reversing the judgment at so of Barampur, passed in case number so in a suit for delivery of vacant possession and permanent etc. The present appellants were the defendant numbers 1 and 2, who were husband and wife respectively. The suit was dismissed by the learned trial court by judgment dated 16/9/2010. Challenging the judgment passed in the suit, the plaintiffs filed RFA number 104 of 2010 before the learned district judge Ganjam Barampur. The appeal at one point of time was dismissed by judgment dated 27/11/2013. Thus, challenging dismissal of the appeal, the plaintiff carried the matter to the Honorable Court in RSA number 91 of 2014. This Honorable Court, by judgment dated 8/3/2018, set aside the judgment of the lower appellate court and remitted the matter back to the lower appellate court with a direction to depute a surveying commissioner, obtain a report and dispose of the appeal afresh, taking into account the legality of the report and the evidence already adduced by both the parties. After the remand judgment, the lower appellate court deputed a surveying commissioner who submitted his report. Thus, after hearing the parties, the lower appellate court, by his judgment dated 38/2018, has allowed the appeal, consequently declaring the suit of the plaintiffs. The defendants therefore have filed the present regular second appeal, challenging the judgment of the lower appellate court.
The facts leading to the present dispute may be indicated in brief. Originally, the suit property was acquired by one Krishna Chandra Panda from the original owner, Swarnamai Panigrahi, by RSD number such and such, which is Exhibit 12. The area is locally called as Swarnamai Nagar. The property is situated in the district of Ganjam. By the time of the sale, there was no settlement in the area. The sale deed therefore did not mention any plot number, but the area were described in length and breadth as 150 hatta and 150 hatta in Odia. The area was locally called as Hatibandha. After purchasing the property, Krishna Chandra sold the property by different sale deeds in 3 different rows. By RSD number Swancho dated Swancho, Exhibit 14, he sold the following property to Janaki Pasupalak in 2 rows. First row I have given. We are not concerned with the purchase made in the first row. Then second row, north-south area length has been given. This length is important, 45 into 75 feet. The boundary of this second row purchase was made as the following boundaries given. On the same day, Krishna Chandra also, by registered sale number such and such, Exhibit 9, sold the following property on Ramchandra Pasupalak, Janaki Pasupalak, son of Janaki Pasupalak, in 2 rows. This is the son and the earlier one the mother. Mother and the son, they both purchased the property in 2 separate bits. Then again, the first row is not relevant for the present purpose. Second row again given, the north-south length is 45, east-west also 75. So the total length becomes 90 into 75. In decimals, the purchase area of each of the purchases made in the second row comes to 77 decimals in 5 links. Square feet calculation has been made here. For the first time, settlement operation started in the area in or around the year 1980. In the ensuing settlement, both the Pasupalak purchasers applied for grant of record of rights. Janaki Pasupalak was granted with Khata number 282, Exhibit 15. Sorry. Out of different plots in the Khata, the present dispute is confined to plot number 610 by 2363, recording an area of 128 decimals. Here the real dispute came. This area is under dispute, though the purchase area of Janaki Pasupalak is 77.5 decimals, 77 decimals 5 links. The recorded area was enhanced to 128 decimals. Here there was a small mistake, 1238. That should be 128 decimals. That is in excess of about 50 decimals. Then similarly, Ramachandra Pasupalak, son of Janaki Pasupalak, was granted with Khata number 734. This is Exhibit 9 by A, with plot number such and such, recording an area of 140 decimals. This area is under dispute, though the purchase area of Ramchandra Pasupalak is 77.5 links. The recorded area was enhanced to 140 decimals, that is in excess of 62 decimals and 5 links. The earlier excess is 50 decimals 5 links, here 62 decimals 5 links. After publication of the ROR, both Janaki Pasupalak and Ramchandra Pasupalak started selling the above 2 plots. The entire purchased land in 2 plots measuring 90 feet and 75 feet were sold to 5 purchasers, namely such and such. 5 purchasers there. Entire plot has been sold. This fact of
including that excess recorded.
No, this is 1975. Excess was sold subsequently. I will come to it. This fact of sale of the entire purchased property has been reflected in the judgment of the Landed Trial Court in paragraph 7 while discussing issue number 1 in paragraph 15 and the findings in paragraph 16 while taking into the account the admissions of Ramchandra Pasupalak as PW7. In the meantime, in the year 1985, the original owner Krishna Chandra Panda again sold the following property in favor of one Sunita Padi. Here the purchase of the present defendants come. Sunita Padi by RS number such and such, Exhibit B. This is the 3rd row I have indicated in the sale deed. The boundary of this 3rd row purchase was mentioned as such and such. The Sunita Padi thereafter sold her purchased property in favor of the present defendant number 2, Renu Devi, by RSD number such and such, Exhibit A, with the same description of the property as given in the vendor's document. In the suit, both husband and wife have been added, but wife is the real owner. Husband has been unnecessarily or for some reason has been added. He is the defendant number 2. After purchasing the property, the defendant number 2 mutated her name in pursuance of the order part in mutation case number such and such, dated such and such, Exhibit C, At this juncture, a clear picture has to be given as to the existence of the properties in 3 rows. The plaintiff's own witness, that is Kachinath Pasupalak, who is the husband of Janaki Pasupalak and father of Ramchandra Pasupalak, who happens to be the vendors of the plaintiffs, has tendered his evidence at PW8. The relevant portion of the depositions of the PW8 are quoted below for reference. In para 30, it has been stated, it is a fact that my son and wife together had purchased an area of 90 feet into 75 feet as stated before. They have since sold the entire area of 90 feet into 75 feet to 5 different persons in the year 1992. It is a fact that Swarnamay Nagar has 3 rows of houses. Then paragraph 15, we have not purchased any other land after 1978. In 1978, there was no existence of 3rd row in Swarnamay Nagar. It is not a fact that by the PW7 and the husband of the plaintiff number 1, PW2. Coming back to mutation case number 1036 by 87, which was filed by the present defendant number 2 during the pendency of this case, the Pasupalak family again sold some land in favor of both the plaintiffs. Here comes the disputed sales in favor of the plaintiffs after exhausting the properties. By registered sale deed number so dated exhibit 1, they sold property to the plaintiff number 2, Lakshmikant Patnaik. By RSD number such and such dated such and such exhibit 10, they sold property to the plaintiff number 1, Josna Rani Patnaik.
This according to you is that excess area?
Excess. It is not in existence in fact, but property is being claimed.
It is recorded in their name. That excess was recorded?
Yes, yes. In the meantime, after order of mutation, the ROR, order of mutation of the ROR, exhibit C-1 was published in the name of defendant number 2. This is the purchase made by the defendants, which was recorded in our name. Long 6 years passed in the meantime, after the purchase made by the plaintiffs in the year 1992. After a lapse of 6 years, the plaintiffs plaintiffs in the year 1998 filed appeal case number 18 of 1998 before the sub-collector Barampur. The appeal having been dismissed, the plaintiff number 1 filed MRC number 36 of 98 before the Commissioner of Land Records and Settlement Orissa Cuttack. This MRC case was ultimately disposed of, setting aside the order passed in the mutation case and appeal case, granting liberty to the recorded tenant to approach the Board of Revenue under section 15 of the Survey and Settlement Act. Thus, after the above order, the defendant number 2 filed 2 applications before the Land Reforms Commissioner bearing SRP case number such and such under section 15B of the Act. During the pendency of both the revisions, the LRC sought for a report from the charge officer who submitted his report in both the cases, marked as exhibit H and HY1. In this report, it has been clearly indicated that there is no reason as to why excess area has been recorded in the ROR of Pasupalak purchases. Thereafter, both the revision petitions were disposed of on 3/10/2020, directing Tahsildar to take up the matter in accordance with law.
What is this meaning of this? To take up the matter in accordance with law means? To make correction?
Make corrections or again inquire into the matter and to pass final order.
What will be the consequence of this order? To make correction of the ROR?
Necessary.
That is what?
Necessary. Necessary. What happened subsequent to the above order is not the matter of record, but for the purpose of information of this Honorable Court, it may be noted that the above order under exhibit G and G-1 were challenged before this Honorable Court in OJC number 441 of 2001, and the operation of the said orders were stayed. In the meantime, however, during pendency of the writ petition, the suit was disposed of. Suffice it to be noted here that there was no interference by this Honorable Court in the writ petition, so far as the order passed in SRP case is concerned. While disposing of the writ petition on 22/2/2017, this Honorable Court directed the Tahsildar to deal with the matter in accordance with law. The same order remains. After the aforesaid order of the Honorable Court, the present defendant number 2 filed fresh mutation case number 1/2017 before the Tahsildar, which was disposed of, confirming the ROR published in the name of defendant number 2 earlier. Therefore, the earlier order ROR also stood in the name of defendant number 1. At any rate, with the false allegation of trespassing into the suit land, the plaintiffs filed the suit with a prayer for declaration of title, for recovery of possession, and for mandatory injunction with other reliefs. The suit was dismissed by the judgment dated such and such, clearly finding under issue number 1 that Janaki Pasupalak and Ramchandra Pasupalak, having no balance land in their hands out of their purchased property, sales in favor of the plaintiffs are void. so the plaintiffs cannot derive any title over the suit property. The plaintiffs that filed RFA number 104 of 2010 challenging the judgment passed in the suit. This appeal also was dismissed by judgment of such and such by District Judge Ganjam. Challenging the said judgment of the London Lower Appellate Court, the plaintiffs carried the matter before this Honorable Court in RS number 91 by 2014. This Honorable Court, by its judgment dated 8/3/2018, allowed the appeal and remanded the matter back to the London Lower Appellate Court for fresh hearing with a direction to the London Lower Appellate Court to depute a surveying commissioner, obtain his report and allow both the parties to argue on the report of the surveying commissioner. The London Lower Appellate Court was further directed to dispose of the appeal on merit after hearing both the parties on the evidences already adduced by both the parties, keeping in mind the observation made quoted paragraph 22 and 24 of the judgment in RS number so may be referred. After I will place their judgment, I am completing a paragraph 14. After aforesaid remand, the London Lower Appellate Court deputed the surveying commissioner, who also submitted a report which has been marked by the London Court below as an exhibit X. After marking the report as exhibit X, the London Lower Appellate Court heard the parties and allowed the appeal, ultimately declaring the suit of the plaintiffs in full. The defendants therefore prefer the present second appeal. The present appellants are also filing a separate application for production of additional evidence to prove the fact of sale of the entire property by the Pasupalak family for consideration of the Honorable Court. It may be submitted in this connection that the London Lower Appellate Court has completely failed to examine the report in its proper perspective. At the outset, it may be submitted in this connection that though in the direction the requirement was identification of the suit properties, the commissioner instead has identified a house inside the properties in question without identifying the suit plots. The existence of the property is not in dispute. Moreover, the question is as to whether the property purchased by the plaintiffs is the same as that of the property situated at the spot. The commissioner has given the four-side boundary of the property inspected by him. The same throws sufficient light on the question of identification. The description does not match with the property purchased by the plaintiffs. This can be examined by referring to the report and the deed of purchase made by the plaintiffs. But without at all examining the report in detail, the London Lower Appellate Court, in most mechanical manner, in paragraph 12 of the judgment, has simply observed that the suit land has been clearly identified. Most material aspect of the matter is that without examining the statements of the witnesses of the plaintiffs, as indicated earlier, who have categorically admitted about the fact of sale of the entire stock of purchased property, property purchased by the Pasupalaks to 5 persons prior to the sale in favor of the plaintiffs, and without taking into account the absence of any explanation as to how excessively more area was recorded in the name of the Pasupalaks in the record of rights as indicated earlier, the London Court below in paragraph 26 of the judgment has come to an abrupt conclusion that the plaintiffs have title over the suit properties. Thus, all other issues have followed this time. This is all about the case. Now, kindly have granted the remand judgment by this Honorable Court. I will just do that judgment, then the report, that will be my conclusion.
Is a copy already filed?
Copy is available on it. Okay. RSA 91 of 2014.
Nice. Place the relevant portion only.
Yes, I'm just placing the relevant portion.
Give this. We will go through all these things. खोजिकी समय नष्ट करियो ना आपण कोन
नहीं
what is it that you want to point out from this court's order?
The remand, the instructions in the remand.
Yes.
Hence, the following
it was not an open remand.
No, it was confined to a submission of report by the surveying commissioner after deputing the same by the Lower Appellate Court.
Yes.
Hence, following the aforesaid decision of the Honorable Supreme Court, since the identical facts and circumstances are available here, the judgment and the decree passed by the Lower Appellate Court is set aside, and the matter is remitted back to the Lower Appellate Court, who would depute a surveying commissioner and obtain his report and allow both the parties to argue on the report of the surveying commissioner. the cost of the survey, etc., etc., etc. The report would be considered by the learned appellate court while disposing of the appeal on merit after hearing both the parties on the evidences already adduced by both the parties, keeping in mind the observation made herein above. That the property is not identifiable, that is also
The commissioner was deputed.
deputed.
Yes.
Deputed, then
Where's the commissioner's report?
report is that has been marked as exhibit X on record also.
Exhibit X.
Kindly-
Only X होगा तो exhibit X तो होगा ना anyway.
The report is there, commissioner's report.
I got it.
Uh,
Which place do you want me to see?
The second page, fixed points, etc. have been indicated. Then page 3.
Yes.
Page 3, the para begins basing on the facts.
Yes.
Basing on the facts and circumstances, I measured the suit house. Suit house. Kindly have a glance. Map is there. Kindly have a glance at the map. In the map is at the last page.
Yes.
A red color boundary has been given, indicating a house over two long plots. The dispute was with regard to identity of the land, not the house.
So it is 2362 and 2363.
Two plots, yes.
Yes.
Now, basing on the facts and circumstances, I measured the suit house, which was identified by both the parties. It is seen in my map, ABCD so. Details is given. Covered under area 61 decimals in plot number so. That means he is measuring the house which is inside these two plots. Had he measured the entire plot or the identity of the two plots, he could have gone to other plots also, the side other adjoining plots, and taken measurement from the other plots also. So the next para 2, in my map ABCD so, covered under area so decimals in plot number 2363. So. Inside that plot, he measuring a portion which is covered with the house only. Then para 3, of course, in the same. Para 1 जो observation से दी district Ganjam covered under area so district Ganjam is in possession of the respondent Srimati Renu Padi and wife of Dr. Krishna Chandra Singh. He also admits that this is under the possession of the defendants 1 and 2. But nowhere in the report it has been indicated as to the identity of the exact suit plot with reference to the suit the description given in the schedule. He goes to the spot, find out say building standing on the plot, and gives a report with regard to the existence of that building on which on two different plots. This cannot be treated as an identification of the plots, whether this is the suit property or suit property somewhere else. With this report, the map is given. I have already indicated. In the map, there is no measurement of the plots. Kindly have a glance.
Yes.
Only a red color square has been given with ABCD map, which is a house. He indicates that is a house inside two plots.
More in 2362 or a little bit in 2363.
But the plots, measurement of plots have not been indicated, or the identity, whether it situates on any row.
Supposing this court accepts your contention, what can be done now?
Again remand.
Again 26-9.
Again remand. And what is the appellate court's?
That you have read out just now.
No, I read out the judgment of this honorable
this court.
No, now I will place just the lower appellate courts.
Yes.
Yes. This is in paragraph 11 of the impugned judgment.
Yes.
I'm coming to the last part, better. Yes, the commissioner's report, examination, the consideration of the commissioner report in paragraph 12.
Yes. Yes, I've got it.
As stated earlier, the surveying commissioner was deputed in obedience to the direction of the Honorable Court, whose report has already been marked as Exhibit X. In the report under Exhibit X, the suit line has been clearly identified. That is all about the conclusion. The Honorable Court in their judgment at paragraph 22 have observed, the observation has been quoted, keeping in mind such observation of the Honorable Court as per the direction content in paragraph 24 of the judgment, it is to be held that plaintiffs vendor Janaki Pasupalak and Ramchandra Pasupalak had purchased the suit plot in the year 1978 under Exhibit 14 and 9 respectively. This means the vendor of the defendant Sunita Padi, who purchased the suit land in the year 1985 from Krishna Chandra Panda, as per the claims of the defendants, had no valid title for the reason that at the time of such purchase in the 1985, her vendor had no valid title and right. Thus, plaintiffs vendor were holding right title over the suit land in 1992 when they executed the sale deed under Exhibit 10 and 1 in favor of the plaintiffs, being purchased the same in the year 1978 under Exhibit 14 and 19 respectively. Hence, the plaintiffs acquired their right title and interest over the suit land by virtue of such purchases from their vendors, which cannot be termed as void purchase as held by the learned trial court. Accordingly, the issue number 1 is answered in favor of the plaintiffs that they have valid right, title, and interest over the suit land by setting aside the finding of the learned lower appellate court. Here, the question as to whether the vendors of the plaintiff had at all any right to sell the property which was in excess, because the recording was in excess. That has been found by the revenue authorities and that has been exhibited.
But the record of right remains as such. It has not been corrected or altered.
No, that was directed to be corrected before the revenue authority.
So that is what I asked you. What was the consequence of it?
My record was kept in that. Original record was maintained.
No, the ROR but still stands recorded in the name of the plaintiff with the excess area included.
Yes. Plaintiff's area included. But so far as my petition is concerned, that has also been recorded in my name, pursuant to the order passed by this honorable in the OJC and ultimately remanded by the MRC in the MRC case, and ultimately ROR was published, recording confirming the earlier record.
So what is your submission? What is the basic ground?
The real identity has not been examined. What was the purpose in the remand judgment passed by this honorable court? That means, in fact, the purchased area of the present appellant's defendant, that is in another place, not the purchase made by the present plaintiffs. In fact, there may not be any existence of the purchased property of the plaintiffs after the exhaustion of the entire property by the two possibles. Because they admit that we have already.
I think this can be disposed of on this point. Of course, he'll have to make his submission.
Yes.
But should we continue tomorrow?
Hello?
Should we continue tomorrow? We'll continue tomorrow. Other matters are there. So if it is a case of, it has to be tested. The commissioner's report has to be tested against originally the direction of this court.
Yes.
Yes.
The dispute was with regard to the identity of the suit law. Now, as he has shown, prima facie I have not gone deep into it, but what I find is that he has actually measured that suit house A, B, C, D and D dash. Marital.
No, there is a plot below that. He has written the plot.
Decimal plot. No, I'm looking at it. Exhibit A.
My lord.
I'm looking at it. Will it meet the requirement?
My lord, this.
He has just mentioned the plot numbers.
My lord, page 3, as he had shown. But here your lordship may see, he has written the covered under this area, covered under area 61 decimals in plot number so and so. In plot number so and so. And then here below also, this covered under 40 decimals, the point number 3, 40 decimals in plot number so and so. So that is the plot. And moreover, this honorable court directed that the commissioner's report will be made, and you argue on that report. There they have not argued anything. So that report was accepted.
by them. Here at this stage, they cannot dispute that. It's a question of fact.
All right. Third and part, list this matter tomorrow. We'll dispose of tomorrow.
Man.
I mean, we'll close it. If
Man.
possible. Tomorrow you will have to give your reply.
Man.
Item 34.
But tomorrow at after lunch.
कल तो हमारा वीकली लिस्ट तो सॉरी इशू था अभी पर सॉरी जो 6-17 अच्छी सॉरी जो सॉरी देखिए कि we'll see. Will come in the supplementary list. So it will be taken off first now.
May I please your lordship?
Yes.
But in this bail matter, the petitioner is inside custody for more than 2 years, 2 months, and the date of custody is 15/5/2022. I am appearing for Binod Lima.
Yes.
Binod Lima. But the fact is that the
Earlier rejected.
Earlier rejected and thereafter specifically assigned to your lordships.
Doesn't matter.
By justice.
Yes.
Not rejected to come after filing of charge sheet. That was the order.
I think Justice Nursing's order.
Yes, and thereafter your lordship is Chief Justice has assigned it as per.
No, he said that the court is not inclined to entertain the bail application. Giving liberty to the petitioner to renew his prayer before the court below, which shall be considered on so minute without being influenced by the earlier order.
Yes.
Yes.
So here, my lords, actually the petitioner was not inside his, was not at the place of occurrence.
Yes.
The occurrence is he was at his house. So 1.5 months after the occurrence, he was picked up from his house.
Yes.
On the basis of a co-accused statement, which is not admissible as per as Tufan Singh's case.
What is the status of the trial?
Trial is going on. 1 witnesses have been examined. Total identification is 68 kg ganja was recovered from the bolero of this person. So he was not the carrier. So on that basis, because he was the owner of that bolero, 2 boleros were intercepted, he has been arrested.
Let us see the FIR.
Yes.
Page 17.
Eh?
Page 17.
Okay.
Last 1, 2, 3, 4, 5. 6 lines.
That is, little place. Today on 3/4/2022 at 8:30, Lalit Mohan Das, along with her.
Where are you reading from?
My lords, at 8:30 p.m.
No, that's page 17.
Page 15. Page 15. Page 17. FIR.
Page 17 does give you clear reading.
Plain paper.
Here a plain paper FIR.
Yes.
Page 17. The table.
पूरा पढ़ा दरकार नहीं है मैं.
I received reliable information from the source. Middle portion I am also reading. Can I proceeded to Nuaganda Chowk in the police bolero vehicle bearing which was driven by AG Devapatra to verify the veracity of the information. On the same day, while we are at Nuaganda Chowk at 8:15 am, I received reliable information from says 2 number of bolero vehicles are coming from Kenduwada dam side and proceeded towards Barampur. On receiving the information, I immediately briefed my staff present with me about the bolero vehicles and took the strategic locations, making a human barricade and keeping the police bolero vehicle near Nuaganda Chowk in between Nuaganda and Dabarkona. At 8:35 am, 2 numbers of bolero vehicles were coming towards Barampur side in a high speed and seeing the police all of a sudden, both the vehicles were stopped just 100 meters ahead from us on the side of the road. From both the vehicles, 3 occupants from the vehicle, the first vehicle, 2 persons, and from the second vehicle, 1 person got down and started running towards the cultivated land. As per briefing, we chased them. D. Kumarika, Rijan Kadraka, T. Sabara managed to catch them at a distance of 200 meters to 150 meters away. At the same time, I, along with ASY, SK, guarded both the vehicles at the bolero vehicles at the spot. Immediately they were guarded and there were brought 2 other vehicles. Immediately I searched for the local independent witness, but due to fear, no one came forward to assist us during checking. Hence, I briefed my local staff. According to be cautious at 8:50 p.m. while we checked first bolero vehicle registration number so and so, we find 2 number of jolly bags loaded in the back side of the vehicle in presence of police staff and detained 3 persons and found there was a reasonable slam of ganja which was coming out from the end. While we checked the second bolero vehicle registration number OR02BB2606 which was kept in a little distance from the first vehicle, we found 3 number of jari bags loaded in the backside of the vehicle in presence of police staff and detained 3 persons and found there was smell of contraband ganja were coming out from the jari bags immediately. Then my lord so and proceeded two valuable, there, my lords,
Chittaranjan
here, my lords, they confessed,
Sahu.
one of them, that Santosh Mishra, there are three persons who were apprehended. Chittaranjan Sahu was apprehended, one Chittaranjan Sahu, two second Litu Patnar.
He was not present at the spot.
He was not present in the spot.
One of the Bolero vehicle which stands in his name, madam.
Okay.
Where
That
two
is the
packets
only
have been
allegation.
recovered, 68, two vehicles, 5 packets, 34 kg each.
So 68 kgs.
From separate sigilist ହେଇଛି କି ନାହିଁ ମୁଁ ଜାଣିନି because there is
From
not
my
there.
vehicle,
But
68
total
kg.
170 kg, 600 gram, but he was not present at the spot.
All right.
And one vehicle stands in his name.
All right. All right. The petitioner is in custody since
Since 15/5/2022. More than 2 years.
2022 in connection with such and such case. The prosecution case is that on receiving reliable information regarding transportation of contraband ganja, police conducted a search on the road during which two Bolero vehicles were detained. On search, contraband ganja weighing total
Total 170 kg, 600 gram.
178 kg, 600 grams.
170, 70.
Sorry, 170 kgs, 600 grams was recovered from both the vehicles. Further, three persons were present. 3 persons were apprehended, being the occupants of the said vehicles. Admittedly, the petitioner was not present at the spot. He was implicated on the statement of on the statement of the co-accused persons, to the effect that he is the registered owner of one of the Bolero vehicles in which 68 kgs of contraband was being transported. Stop. There is no other material to show either the presence of the petitioner at the spot or of being in conscious possession thereof. That apart, the petitioner's implication is on the basis of the statement of the co-accused persons. As such, the ratio laid down in Tofan Singh versus Wanso squarely applies to the case. Take into consideration all the above facts, I am inclined to allow the prayer for bail. Let the petitioner be released also each day appearance without seeking representation.
Data CA achi as per rejection order condition.
The
Trial is going on.
He shall appear before the IAC of Kothana.
ଗୋଟାକେ 110 ରେ acquittal ହେଇଯାଇଛି।
କୋଉ
ଆଉ
ଥାନା?
ଗୋଟେ ପଦମପୁର PS ଅଛି।
ମାନେ ବରଗଡ଼ ଥାନା, ବରଗଡ଼
Padampur, yes, ma'am.
He shall appear before the IAC of Borgad police station on every Sunday at 10 a.m. for a period of 6 months. Yes.
Item 35.
I'm appearing for the on behalf of the victim, Mr. Kananwadi is appearing for the petitioner. Pursuant to my request, matter has been sent to mediation. Now mediation is going on.
29/7.
29 July.
The report of the mediator indicates that the next date of mediation proceeding is fixed to 29th of this month. Hence, list this matter on
8th August.
8th August.
Item 36.
ତାଙ୍କର କହୁଥିଲେ କି ମାନେ ଯୋଉ ଏକ୍ସଟେନସନ ଟା ନେଇନାହାନ୍ତି ଆଜି ଯାଏଁ ଅଛି ତ
Interim bail ଟା 28 ଯାଏ ଦେଇଥିଲେ।
28
Yes, 28 July.
All right. The interim bail shall stand extended till 8th July.
8th August.
8th August. Yes.
Item 36.
extension of time.
First time. 2 weeks.
Item 37.
But I'm in custody since 26/10/2022. Only difficult is.
You have surrendered?
Yes, surrender certificate I have filed, Mano.
You filed? All right.
I surrendered 1/7.
1/7?
My lord.
I tell you.
ଦେଇଛି
Hey, this surrender. How is it done?
I got it, my surrender certificate.
Yes, surrender certificate is the one. 1st of July, let some time.
Right.
ଏବେ 6 ମାସ କେତେ ଦିନ ବେଲେ ଯାଇଥିଲା
3 ମାସ ଯାଇଥିଲେ ପୁଣି 6 weeks extension.
In fact, out of 4 accused persons, 3 have been granted bail by my lord. The difficulty is the prayer for bail earlier rejected by this honorable court. After rejection of my prayer for bail, subsequent other 3 have already been granted bail. And if you also will find the who accused bail order, I have annexed that order. My lord has specifically also kindly page 41, page 41, para 7.
Yes. Yes.
That is Soumya is the main accused who gave the fatal blow by means of a
We'll consider it. He has just he has availed interim bail for more than
ସେଇଥିପାଇଁ ହିଁ ତାକୁ ଏଣ୍ଟ୍ରି ବେଲ୍ ଦିଆଯାଉଥିଲା ସେଇଥିପାଇଁ ଯେ ଓନ୍ଲି ବିକଜ ତାର ରିଜେକ୍ଟ ହେଇଯାଇଛି ଅଦର ପଳେଇଲେଣି ସେଇଥିପାଇଁ ଇଣ୍ଟରିମ୍ ବେଲ୍
4.5 ମାସ interim bail ଯାଇଛି ଏବେ ରିସେଣ୍ଟଲି କରିଛି ଆଉ କିଛି ଦିନ ଯାଉ ଗ୍ରାଣ୍ଟ ହିମ୍ ରେଗୁଲାର ବେଲ୍ କଣ ଅଛି ବଟ୍ ଦିସ୍ ୱିଲ୍ ଲୁକ୍ ଅଡ୍ ଏଇ ମାସ 1 ତାରିଖ ସେ 4 ମାସ 4.5 ମାସ ରହିଲା ପରେ 1 ତାରିଖ ଜଏନ୍ କରିବେ ସାଙ୍ଗେ ସାଙ୍ଗେ ପୁଣି ବେଲ୍ ହେଇଯିବ
ସାଙ୍ଗେ ସାଙ୍ଗେ ତମକୁ ଦିସ୍ ଇଜ ଦ reason for which I am filing interim application. I know the difficulties.
So list this matter. Well, date for the 1 week after.
Hi.
Item 39.
In item 39, what last occasion, State Council has requested to obtain instruction with regard to
item 39 your
genuineness of medical certificate.
Your matter.
Yes, yes.
Sorry. That is not. Yeah. 38 भूल कर दिली 38 अच्छा अच्छा
My application flag है
it's all right. Yes, what instruction have you obtained?
Yes, ma'am. Instruction, my lord, that medical documents has been verified, but the victim is not staying there at that address, my lord. Several times the police has gone to the place to verify the health condition, but she was absent on that address. So correct address dele good roach will verify the health condition.
Yes.
ତା ବାପ ଘରେ ରହୁଛି ବିକଜ କେହି ନାହାନ୍ତି ତା ବାପ ଘରେ
ସେ address ଟା ତ ଆମକୁ କହିଥିଲେ ଆମେ
ହଁ ସେଇଟା
address है जो साइंस verify कर दो किसी but next week it will come.
Yes.
London State Council has obtained instructions that the medical documents submitted by the petitioner appear to be genuine, but submitted by the petitioner. But the victim has not been able to be examined as she is not residing in the address mentioned. Then counsel for the petitioner is directed to produce the correct address by tomorrow, so that the State Council can take appropriate instructions. Is this matter next week?
Yes. Item 40.
Not legally, no, 21 C of NDPS Act mirror. On the basis of co-active statement, petition has been implicated in this case. In some whose position, my lord, the complainant should granted bail by your lordship. 160.
Submit.
So the other Sheikh Aimat alias Budhiya. There he had the allegation was that he had delivered brown sugar to Samir Khan.
Sheikh Ahmad delivered the brown sugar to Samir Khan, and that Sheikh Ahmad, he confessed that he has procured the said brown sugar from the present petitioner as per the FIR.
The petitioner is in custody since?
My lord, 1/5/2024.
1/5/2024 in connection with such and such case. One Sheikh Aimat, EIMAT alias Budhiya, was arrested in connection with the case for supplying 264 grams of contraband brown sugar to one Samir Khan, from whom said brown sugar was recovered. In course of investigation, said Sheikh Ahmed confessed to have obtained the brown sugar from the present petitioner. There is no evidence to show the presence of the petitioner at the spot or of. There is no other evidence to show the presence of the petitioner at the spot or of possessing the contraband. Moreover, his implication appears to be. His implication appears to be only on the basis of the statement of the co-accused. Stop. As such, the ratio recited in Tufan Singh versus so squarely applies. Considering the submissions as above and the materials on record, I'm inclined to allow the refer bail. No, that Sheikh Ahmed was not granted bail. Samir was granted.
Samir granted bail.
From whom it had recovered.
Considering the submissions and the fact that co-accused Samir has already been granted bail, I'm inclined to take a lenient view. Let the petitioner be released. Each day appearance, he shall appear before Jodhpur Police Station on every Sunday at 10 a.m. for a period of 6 months.
Yes.
Okay.
Item 41.
This application has been filed for modification of a lordship's order dated 18/3/2024. By the order dated 18/3/2024, my lord, your lordship was pleased to allow the bail application of the petitioner and on certain conditions, my lord. One of these conditions, my lord, he will appear before the IIC Koida on every Sunday, my lord. He is a government servant. And he used to appear before the police station. I have annexed the attendance of the petitioner under Annex 1 of the petition matter. And later on, it was also modified that on alternative Sunday matter. That what happened actually, he is going to the police station unless they are detaining him 3 to 4 hours, and in the meantime, they are not filing charge sheet. 7 to 8 months have already been elapsed, my lord. This is the dispute between father and son. So, my lord, I pray that condition may be waived out, or alternatively, in each month, he cannot go to his native place to look after his alien parents.
Each month, or every fortnight, every week.
No, fortnight ହେଇଥିଲା modification. ଗଭର୍ଣ୍ଣମେଣ୍ଟ ସର୍ଭେଣ୍ଟ ହଇରାଣ ହଉଛି। ଶନିବାରଟା ଗୋଟେ ଦିନ ଛୁଟି, ରବିବାର ଆସି ପୁଣି ଥାନାରେ ରହୁଛି, ସେ 10ଟାରେ ଯାଉଛି, ଆସୁଛି 2ଟା 2:30 ଏମିତି କରୁଛି। କହିଲେ ସାର୍ ରାଉଣ୍ଡରେ ଯାଇଛନ୍ତି, ଆସନ୍ତୁ କରିବେ। ଅଲରେଡି 8 ମାସ ହେଲାଣି ଚାର୍ଜସିଟ୍ ଦଉନାହାନ୍ତି।
ସେଇଟାକୁ ଆଖି ରଖି ତ କରାହେଇଥିଲା ଏ କଣ୍ଡିସନଟା।
ଦଉନାହାନ୍ତି ଚାର୍ଜସିଟ୍ଟା।
ଚାର୍ଜସିଟ୍ ଦଉନାହାନ୍ତି ତ, ଯାଉ ଥାନାକୁ ଯାଉ।
ଯିବାକୁ ମନା କରୁଛି, ମାସକୁ ଥରେ ନହେଲେ କରନ୍ତୁ।
It is submitted that the petitioner is a government servant, for which the condition imposed by this court while granting him bail to appear before the IIC of Koida Police Station on every alternate Sunday is causing a lot of difficulties, as he has to spend considerable time in the police station to mark his attendance. So, considering the submission as above, the condition number 1 in order dated 18/3/2024 is further modified to the extent that he shall appear before the IIC of Koida Police Station once on the first Sunday of every month at 10 a.m. First Sunday. Yeah. All other conditions shall remain intact.
Item 42.
Yes.
May I please, Lordship? Lordship, modification of order dated 22/2024, Lordship. Lordship, in this case, Lordship granted bail application to the present petitioner with condition depositing cash of rupees 50,000, Lordship. Lordship, present petitioner poor person here unable to arrange the same, Lordship. My little bit prayer is to kindly waive out this condition, Lordship.
ପୁରା waive out ହବନି। 2
Lordship,
ଲକ୍ଷ 35,000 ଟଙ୍କା ଚୋରି କରିଛନ୍ତି।
yes, Lordship, but he unable to arrange the same, Lordship. One of the co-accused person granted bail without cash security, Lordship. He's putting same.
Yes, what is it? The petitioner was granted bail on 22/2/2024, inter alia on the condition of depositing rupees 50,000 towards cash security.
Yes, Lordship.
It is submitted that the petitioner has not been able to arrange the said amount because of his stringent financial condition. Stop. This court finds that despite being granted bail since 22/2/2024, the petitioner is still languishing in jail custody, which almost amounts to refusal of bail, which this court did not intend. In such view of the matter, the condition to deposit rupees 50,000 towards cash security is hereby waived.
This is anticipatory bail,
Yes, yes.
not in custody, anticipatory.
Anticipatory.
Court custody କହିଲି
For linguistic custody.
Languishing in
Custody.
ମୁଁ ଜାଣିପାରୁଛି ତାହେଲେ ହବନି ତାହେଲେ 20,000 କରିଦିଅ 20,000 କରିଦିଅ ତ modify କରି 28,000 କରିଦିଅ 20,000
ହେଲା 20,000
Lordship, kindly consider 5,000, Lordship. Lordship, 5,000.
bargaining
Lordship, ଦେଇ ପାରୁନି ବୋଲି ଯାଇ ହିଁ ପାରୁନି ସେ
ତାହେଲେ ସେଟା waive କରିଦିଅ
Lordship,
Hello.
Lordship, another is para 3, Lordship, and that is 392 has been written offense under section 392 has been written instead of 395, Lordship.
Yeah.
Another, Lordship, extension of time.
correct
Lordship, 1 month extension.
1 month କଣ ପାଇଁ
Lordship, she is
Surrender
surrender 2 weeks for the time 2 weeks
Lordship, 3 weeks.
no ସବୁ ନେବେ ନା କଣ ଆପଣ
Lordship, 3 weeks is
ନାଇଁ, ନାଇଁ, ନାଇଁ।
staying in Gujarat, Lordship.
ନାଇଁ ସେ ଯୋଉଠୁ ଗୁଜରାଟରୁ ଘଣ୍ଟାଟେ ଲାଗିବ ଆସିବା ପାଇଁ ବା 2 ଘଣ୍ଟା ଲାଗିବ ବେଶୀ ନାହିଁ ପ୍ଲେନ୍ ଆସିବ କଣ ଗୁଜରାଟରେ ଯିଏ ରହୁଛି ମାନେ ଭଲ ପଇସା କମଉଥିବ ସେ ପଇସା ନାହିଁ ବୋଲି ସେ କହିଲେ ବୋଲି
It's
କଣ
a daily labor, Lordship.
ହଁ ଡେଲିଭରି ୟୁ ନୋ ହାଉ ମଚ୍ ଦେ ଆର୍
Lordship, as
अर्निंग
per the instruction of law and food.
no ହବନି
Conducting
ସେତିକି
council, Lordship.
ନାଇଁ ଆଉ ହବନି
My big pardon.
yes
In that parameter, can we mention till submission of cash? You month
ଯାହା ଲେଖା ହେଇଛି ସେଟା ସେୟା ଲେଖା ହବ
till submission of cash.
till submission of charges ଯଦି ଲେଖା ହେଇଥିବ ତାହେଲେ ହବ
So condition.
ସେ ଲେଖିବେ ତ item 43 wait lords lordships the petitioner the in-laws lordships father-in-law mother-in-law on 25
She was implicated, man.
yes
I have marked in the file. କୁହାଯାଇଥିଲା କି what is the basis of the implication? What is the statement?
ଏଥିରେ ତ
Was
କିଛି
made.
ସେମିତି ଅର୍ଡର ହେଇନି simply list this matter on 8 July ହେଇଥିଲା ଆସିନଥିଲା ଆସିବ ତ
ନା ନା ହେଇନଥିଲା ମୁଁ ମାର୍କ କରିଛି ଫାଇଲରେ
Yes.
ଲେଖିଥିଲି
so what have you obtained
no your lordship directed the petitioner.
yes no your name is not there because your earlier application was rejected
Yes, that's why.
so
What is the basis?
have you been implicated in the meantime
My lord, in this case, nobody has been named in the FIR on the basis of the police constantly coming and questioning me
ହବନି
for my presence.
ନାଇଁ ହବନି
My lord, other bail applications have also been allowed on the same.
I'll recall those orders no Mr. Kanango you come forward say that such and such person has named me
Yes.
so I am apprehending arrest
My lord, nobody has been arrested
So
in this.
why are you worried
My lord,
your reason to believe is not reasonable that's all
my lord, but 3 other persons have been granted bail by this honorable court. My lord, I have annexed in annexure 3. This is one, and in annexure 3, 2 others have also been granted bail. I have annexed the orders in annexure 3, my lord, 3 series.
oh I may have, because that is after obtaining instructions
Yes, my lord.
you find
The
out whether
the instructions
yes, you
were
find out
I will find out.
you find out
Your lordship.
the instruction was with respect to the injury, whether the injuries were simple or.
but he must have brought this case diary also he must have also brought the case diary so whether those people may have been implicated, we don't know. In your case, you must come forward with a definite case that yes, you have been implicated.
Well, we belong to the same village and we are being searched for questioning.
Why should you be clothed with a protection order unless there is some reasonable, apprehension of being arrested? All right, the State Council shall apprise the court as regards the basis of implication of the petitioner, if at all. List this matter
8th August.
on 8th August. Yes.
May Lordship, may I pray for protection till the meantime, my Lord?
No, unless I'm satisfied that you are involved, I will not grant any protection. Yes.
My Lord, grateful.
Item 48.
Fact of matter, in the past application, past item, your lordship, that is the second bail application of mine. That may be, I may be permitted to not press that application and the name may kindly be allowed.
Just hold. You are not pressing.
First, this
Bill number 6536.
Yes, sir.
Not pressed.
And my lord, I may be permitted to correct the name and record has been called for.
Which one?
This is 6536, my lord.
What name do you want to correct?
Mataji Das. Instead of Das, my lord, it has been wrong.
Das to likha is secondary.
In the secondary properly addressed.
First time,
my lord was pleased to call for the record.
I don't understand. In this first case,
in the first case, my lord, Mataji Das.
You are already permitted to correct the typographical error.
Mataji, yes, your lord.
It's the first matter.
First matter.
So now you want to withdraw it.
Now I want to withdraw that.
End of the matter. So what remains?
My lord,
that will be withdrawn.
Yes, your lord.
Yes.
I do not.
Yes, my lord.
Permitted to withdraw.
The second one,
My lord,
is right. Second, cost title ठीक अच्छी.
Second,
in the yes, your lordship. In the second application, your lordship, on the last occasion, I had with all respect, your lordship, I had prayed before your lordship that this petitioner happens to be the mother-in-law, and your lordship had correctly passed an order directing her to surrender, and in the one-day disposal order was passed. My lord, what has happened? An important thing has not been brought to the notice of your lordship, that she is looking after an infant of 2 years old left by the deceased husband is in jail. Po jail rahla ma pakhre se chotiya chuata achi. So for that reason she is unable to surrender. If she will surrender, my lord, definitely. If your lordship will be pleased, it may be indicated that the lower court may kindly take note of that an infant is living with the petitioner. That may be taken care of.
But this is a anticipatory bail application.
Yes, sir. Yes, sir. Se puo ko bahar kareba ପାଇଁ ବି he has no money at all. File करे एपर्यंत से file भी करनी for 2 years.
You are the mother-in-law.
My lord, I am the mother-in-law.
Yes. So छुआटा कहाँ?
छुआटा more granddaughter poor
deceased. छुआटा आपन पाखरे अछि.
छुआटा मोरी पाखरे अछि. In May 2022,
considering the submissions, the order dated so and so is modified to the extent of adding the following sentence after paragraph 6. While disposing of the bail application, the courts below shall take due note of the fact that a 2-year female child being the granddaughter is residing with the petitioner in her house as the after death of its mother, after death of her mother, that is the deceased. Yes.
Well, some time, maybe 15 days time.
2 weeks for the time.
Item 49.
49 may please. In case of only my limited prayermanship
That kindly the present person are praying for same day disposal. The all other co-accused person has been released by the law and court below, my lordship.
Yes. All right, same order for them. First or second order.
The parity could be.
Parity one.
Parity, my lordship, the co-accused person has been released by the law and court below. Other co-accused person.
All right.
So parity.
Parity will go.
My lordship. Obliged.
Item 50.
May I plead your lordship? Your lordship, the present application is regarding modification of order dated 6/3/24 passed by Honorable Third ADJ Bhubaneswar. Wherein the conditions, the learned sessions court put another condition of cash surety of rupees 2 lakhs, your lordship. Which is, this petitioner is unable to pay, your lordship. Your lordship, before arrest in ABLAPL number 13120 of 23, which was disposed of on dated 15/11/2023 by this honorable court.
Yes, what do you say?
Lord, they have treated 7 lakhs for providing a car, husband and wife. And this present petitioner is the Usar and Barik, wife, mother. So 2 lakhs.
Yeah, lady.
Lady.
I will waive it. The petitioner was granted bail. Your lordship. By the learned third additional session judge Bhubaneswar. By order dated 6/3/2024. Inter alia. On the condition of depositing cash security of rupees 2 lakhs. So it is submitted that because of financial stringency, she is unable to pay the amount. As a result of which, despite being granted bail, she is languishing in custody. This court finds that the order granting bail was passed on 6/3/2024. That is about more than 4 months back. Because of the condition imposed, the petitioner is still in jail. Stop. This amounts to refusal of the bail. In such view of the matter, I am inclined to take a lenient view. The condition number IV under paragraph 6 of order dated 6/3/2024 passed by the learned third additional session judge Bhubaneswar in BA number 370 of 2024 is hereby waived. All other conditions shall remain intact. Sorry.
So item number 25.
Yeah, also one more thing. I have filed an IA for delay condonation.
Delay condonation. Considering submissions, delay in filing of the application is
Lots of urgent copy in course of day.
Course of the day.
Public.
So item number 25.
Item 25. Mama Pierce, raise this matter one week after. Yes. Any other matter?
Item number 27.
27.
I filed an application for transfer of CP number to 74 of 2023 from the Court of Law and Judge Family Judge Kendrapada to Family Judge Kotak. As the petitioner has no source of income and she is permanent resident of Kotak city.
Present counsel for the petitioner is present. None appears for the opposite party. No, you got the I would issue. Allow for transfer allow for them. Allow. You talking about 44 national mention करते Yes.
I mean, physiology, my lord. Item 44, your lordship, offense, my lord, 52A Excise Act, your lordship. One of the co-accused has already granted bail by this honorable court, my lord. So, order is at turning page 9, your lordship. Turning page 9 and 10. A
Same order.
BLA
Same order.
175 liter ideally.
Yes.
Obliged.
CORAM correction.
Weekly list item number 11.
Ajivine,
Yesterday,
you
yes,
had informed him.
I had informed.
You will allow it?
Yes. First application is permission because state was not included as a party.
I have
Food for declaration of tax.
I think there has to be a condonation of delay first.
Yes.
No.
I have explained the delay, your lordship will kindly find. When a mutation application was filed to mutate that.
Ma'am, weekly
and-
11, my lord.
Yes.
And they are online, my lord.
Yes, it has been adjourned twice due to your
No,
absence.
that is because the very unfortunate part is, despite me appearing regularly for your lordship, my name is not indicated in the list.
This is a weekly list, so it cannot change midway. So last time
No,
you
my
on
lord,
your
very sorry, my lord, but I am filing my objection. 3.5 years delay and leave to appeal petition. Your lordships have been pleased to hold that the state government cannot take a very separate stand with regard to condonation of delay. They have to be treated the same way as a common litigant. That is one part. Second is with regard to leave to appeal, that should be substantive prejudice to the party. I will demonstrate both the things.
you are supposed to have that document ready with you. Tomorrow, pass over.
So item number 38.
Item 38.
Lordship, my senior is on his legs for one pass.
So you start. You begin. Mr. Rautra sir, you are waiting for which matter? Both sides are there.
That matter because interim order has been passed at
Who's your other side?
We have already intimated yesterday. My friend also intimated him.
Who's appealing?
So Mr. SK Das.
He has not appealed.
He has not appealed.
He is for the appellant.
He is for the appellant.
କାଲି ଯାଇ ୱେଟ୍ କରିବା କାଲି ଯାଇ ଅଛି ଲିଷ୍ଟ ତ
Until afterwards, I will tell how not next to
okay କାଲି Mr. Vishwa will be there at least one chance should be given the weekly list ଅଛି ନହେଲେ ମୁଁ I would have passed some order all right yes sir
20 taxes a letter ଅଛି but I think it's out kala let us know out kala
ଯଦି ହବ କରିଦେବା
ହଁ
dismiss ହବ appeal ଟା
ନାଇଁ ସେ ଯୋଉ order 7 rule 10 ଗୋଟେ ଦେଖେଇଥିଲି
then I will pass that order
again
I will pass order
10 sir can have a look at 10A
କାଲି ଆମେ ଦେଖୁଥିଲେ ନା we have seen
10 ରେ ଅଛି appellate court has got the power to set aside and remit the matter back to the trial court for the plaintiff to withdraw the suit तो सी যদি allow करे तापर सेठी को डेट फिक्स करिवे हमर काउंसिल रे कि पार्टी जाई कि विथड्रॉ करिवो immediately he will file it here so that the limitation can be saved or 10B re the trial court can also or appellate court can also remand the matter back or remit it to transfer it to the court where it should have been filed.
I think this court can also remit it to the trial court.
I think 10B re if you also looks at it.
10B.
10B. Order 7, Rule 10B. Government area का सब वही
No, power of appellate court to transfer suit to proper court.
ସେଇଟା ସେଇଠି ଅଛି ସେପଟ ବହିଟା
You want the CPC?
sir ଏଇଠି ବାପଟା ହଁ ସେଇଟା ଏଇଠି ବହି ନେଇକି ଆସିବେ ତ ବହୁତ
ଆମେ ଯେତେବେଳେ ତାଙ୍କ ବୟସରେ ଥିଲୁ ଆମେ କେବଳ ବହି ହିଁ ବହୁଥିଲୁ।
Okay.
I have also assisted you sir like that. ବହି।
ନାଇଁ ମୁଁ ପ୍ରତି ଫାଇଲରେ ଆଟାଚ ବହି ରହିବ ନିଶ୍ଚୟ। ନାଇଁ ଏଥିରେ you have to find out the book. I think there is a provision ବହି ଗୁଡ଼ା ବି ଆସିପାରିବ।
Yes.
Where an appeal, on an appeal against an order from the return of the plaintiff, ଏଇଟା 10B ଟା ହଉଛି ଅଲଗା।
10A ଟା ହବ।
ହଁ ଏଟା ହଉଛି power of the court to fix a date of appearance of court, dates will file after his return.
Why we can simply
Sir,
direct the I mean after setting aside this order.
10A, A ରେ ଖାଲି ହବ। If lordship looks at 10A, return of plaintiff, say explanation ଟା କହିଛି sir, explanation if lordship looks at, that is very important.
That a court of appeal or revision may direct after setting aside the decree
Yes,
proceedings to
putting aside the decree to
return of the plaintiff under this
also. So ଆପଣ set aside କରିକିରି ପଠେଇଦେବେ to be presented in a proper court.
But this return of the plate has to be done at the trial court.
Trial.
The original plate.
ଏଠୁ transfer ହେଇପାରିବ 10A ରେ ବି appellate court power ଅଛି, but still then ଆପଣ ପଠେଇଦେଲେ better.
To the trial court with liberty to the plaintiff to take return of the plate
Again.
for proper presentation before the appropriate court.
Appropriate.
Passport.
Again. So the order dita set aside हो गया ना, stands a bar. The explanation.
Item 29.
Item 28.
28. Okay. Judgment reserve कर दूँ।
हाँ।
Sir मेरा judgment reserve कर दूँ। Hearing concluded, judgment reserve.
30 टा hearing करिए।
30 टा कौन लंबा चली उतना।
टाइम लगेगा उनका chief court order।
ठीक है। नहीं, I was asking her to start, begin.
से आपके पढ़ियो पूछना है, I have to go through it.
All right.
Next week ଆସିଲେ।
Let's just matter next week. All right. Next week no, ता पर week. 5th August.
Transfer item 43. Transfer item 44.
This matter, your lordship may kindly excuse me. Yesterday, my associate made a prayer for today. In fact, I am ill. 10-15 କାଲିଠୁ ଝାଡାରେ since it is adjourned to today passed over, I must come.
ସେମିତି କହ ତ ଆପଣ କାଇଁ ଆସିଥିଲେ କାଇଁ କହି ଦେଇଥିଲେ କଣ ହେଇଯାଇଥାନ୍ତା।
She is also
କାଲି ବି ଯେ ତାଙ୍କ ଆସୋସିଏଟ କହିଲା ମୁଁ ଦେହ ଖରାପ ଅଛି ଆଉ ମୁଁ କଣ କରିବି।
Take it up then in the week commencing 5th August.
5th August.
5th August.
Week commencing 5th August.
Another item I am voting 50 टा से खाली after 50 टा same prayer my associate would make. 50 बसी।
Item 50.
ଏଇଟାରେ entry order ଅଛି, ଆରଟାରେ ବି ଅଛି।
Entry order to continue?
ହଁ, ଆରଟାରେ କହିବ।
ଲାଗିଦେବ।
ମୁଁ ବାହାରେ ବସିଛି ମତେ ଭଲ ଲାଗିଲା, ଭିତରୁ ଆସିଲା ବେଳକୁ କାଇଁ ଏସି ରେ ହଉଛି।
ନାଇଁ ଠିକ। ହଁ ସେଟା ବି 5th August କୁ ଯିବ। ଆଉ କିଛି ରହିଲା? ଆଉ କିଛି ନାହିଁ? ଏଇଟା ଜଜମେଣ୍ଟ କରିଦବ।